Number 30, lordship, this matter can be taken up some other day along with, it should tag up with criminal appeal number 60/23, lordship. LCR is lying with that case.
Item number 30.
30, it should be tag up with criminal appeal 60/23, lordship.
Criminal appeal 60/23. Why it is an order column, in fact?
Because lordship
LCR was wrong.
The LCR was tagged with the co-appellant case.
What?
Highly over.
Oh,
May it please your lordship.
after vacation. Yes.
May it please your lordship. With apology, my lord, item number 29, it has been listed on our mention, my lord. We have
What?
mentioned the matter for listing, item number 29.
Yes.
It's a biodome matter. I checked up. Actually, the matter should go to the Lawazim court. Service is not complete, so maybe it will not be correct. My lord, may be pleased to send it to Lawazim court on respond number 6.
On the last date, was there any order for that matter?
No,
to
no,
be-
I think. So we
It
made
was
a
not.
mention, it was for service notice and the
Yes,
report
obviously.
on that. The report is there. So for 4 respondents, the service is not complete. It is showing 3, actually 4, 6, 10, 11. I was under the wrong impression that the service is complete, so the matter should come up for, then we post it for hearing. The matter may go to Lawazim court, otherwise it is not for 29. My apologies, I maybe mentioned for the listing of the matter. Position number
6, 10, and 11.
6, 10, 11.
6, 10, 11. I'm trying to have it. Now, so
On 6, 10, 11. We'll pray there for the presumption of service.
but here the notice was till last occasion notice was awaited. Service
The
was awaited.
office note would reflect, my lord,
Ah.
that in 23, everything was dispatched. Rest they got except 6, 10, 11. So the presumption would come under the act, my lord, section 27. But the Lawazima code would not have said, therefore I'm making mention here. I'm sorry, I made a mention for listing here.
This is awaited till 6, 10, and 11. And as per office note dated 4/12/2024, so it will set the services still awaited for respondent number 6, 10, and 11. In that context, Mr. Bonik, the learned counsel for the petitioner, submitted paid to send it for Lower Jama Court for service. Lower Jama Court will pathai dibo khali, simply list accordingly. Okay. with
Grateful.
this.
Yes.
Item number 20, lordships. That matter will be taken after 2 weeks.
20.
Lords. And for respondent number 3,
Respondent number 3, have you taken consent?
I have
of the
taken
other
consent
side?
from the.
It will be the consent of the other side, the learned counsel for the respondent, paid for and so and so. List after 2 weeks. 2 weeks, that means after vacation, will be after vacation.
Much
Okay.
obliged. Where with the lordship? I beg to mention item number 14, lordship. No such matter, lordship.
1/4.
1/4, lordship.
Oh.
Learned senior counsel, Mr. Curious on partial difficult, lordship. Matter will be taken up next week, lordship.
Who is the senior counsel?
Mr. AC Sommer, lordship.
AC Sharma. Next week?
Next week.
No, it won't come next week. It will come after vacation only.
No such matter.
Now we don't have any time. After vacation.
May I please, your lordship? Lordship, I beg to mention item 24, lordship.
24. Yes.
Lordship, would concern of the respondent, lordship, matter may be adjourned for today, lordship only.
You are for the petitioner.
Petitioner, yes, lordship.
MSK Malaka submitted that around and the request koi dibo baki manala number. After 2 weeks, you're suggesting? After 2 weeks,
After vacation, lordship, I have.
after vacation. Okay.
I'm getting this.
I recommend item number 3, my lord. Kindly adjourn for the day.
Item number 3. Why? What is the problem?
On behalf of SC Business, we have some difficulty.
He has some difficulty. SC Biswas has some personal difficulty. List after vacation.
Obvious.
May I please elect? My lord, I beg to mention item number 19, my lord. My lord, some instructions are awaited from the client.
You're for the petitioner or
Yes, ma'am.
have you taken consent of the
Yes.
other side respondents? Otherwise, is there any interim and all? No.
No. My lord, may fix it on third of January.
3rd of January, I can't say now. I have a no? After vacation. It will be listed after vacation only. Don't go, we're not going to fix any date, in fact. Automatically it will come. After vacation.
May I please your lordship, with consent of other side, I beg to mention item number 18, matter may be taken first week of January.
You are for the, you are for the petitioner or respondent?
Petitioner,
You have taken consent of the other
other
side?
side. I am for the respondent, lordship.
You are for the
Respondent
respondent?
number 2, lordship.
After vacation it will come.
Obvious.
May I please, your lordship, I beg to mention item number 9. The matter may be passed over for the day, your lordship.
Item number 9.
9.
You are for the petitioner?
Yes, lordship.
Request for you after vacation.
Your lordship, before the vacation, any day, your lordship.
No date at all.
Your lordship, the matter is urgent.
What to do? We don't have any dates.
My
After
senior
vacation.
Randeep Sharma was supposed to appear, lordship, in this matter, but he is unwell, so only for
After
the
vacation it
passport
will
for the
come.
day, your
Or
lordship.
after 1 week, what will do?
Yes.
Yeah, we are fixing it after 1 week. If registry can fix it, then it will fix up.
Much love.
After that.
Much obliged.
German rule will be what happened.
For withdrawal item.
Yeah.
Sorry. Lordship, I beg to mention item 47, lordship. LCR was called for that. LCR is not received.
Here LCR was called for.
LCR was called.
It's a NDPS matter. NDPS
And-
matter. LCR I have defeated. Issue reminder is you will do the needful. List after vacation. You want any fix it or after vacation it will come.
Any
Obviously
date, lordship.
after vacation.
After vacation.
After vacation. 20.
For withdrawal item 1. My lord, I may be allowed to withdraw this petition. It's a criminal revision petition.
It was a criminal petition.
Criminal revision petition.
Oh, sorry, criminal revision petition.
My-
As per the instructions of your.
Yes, yes.
I heard Mr. P. City submitted that it was the instructions of his client. He wants to withdraw the same. Accordingly paid for disposal of the same on withdrawal. Prayer allowed. Matter will be disposed of on withdrawal. Okay, withdraw.
Item 40.
This is also a revision petition.
Yes, lordship.
Want to withdraw this one?
Yes, lordship.
You are MS,
Bidas on behalf of AM Ahmed.
Mr. Bidas.
Bidas,
Bidas, MS Bidas, appearing on behalf of Mr. A.M. Ahmed. As per instruction, same order, disposal. It will be disposed on withdrawal.
Item 2.
Yeah, please, Lord.
Yes,
That's it, NDPS mirror, my lord. Certificate mirror.
Scan copy of
This was behind about for more than 230 days.
what is the instruction, whether evidence is already started or not yet?
No, charge no.
Charge not yet framed.
LCR will be required in this.
Want any fixed date or after
Scan
vacation?
copy of LC.
Yes,
After
obviously.
vacation.
After vacation,
Yes.
date to be fixed or no?
After, it's like. Lordship, can it be on 23rd of January?
23rd, 23rd of January. Registry will call for it. Okay, we are calling for the scan copy of the LC.
Kind of. Obvious.
41.
May I please, Lordship, my lord?
Yes.
Already it's 22 days behind the bar, my lord.
That's
What nature of case?
plus 7 PCF. Can be on 13th color from case study.
What, when?
On 13th, on 13th.
No, no, we are not fixing any date before.
Well, because already 24, 22, 3 days, madam.
Hmm.
It will be
23 days.
32 days by then, madam. 60 days of mandatory period. Only 4,000 rupees, right? Madam?
Insisting, but it will all be,
Because,
will be left over in
Most
fact.
of the investing done, pre-tax, post, everything is done.
That I cannot say, can
Voice
it be
central is
13?
done. madam.
Lordship,
According to plan, 30.
so we can try it on 16th.
Okay, 16th. All 40 is, yes. Case diary 16 corridor, 16 12.
Try on 13th. If possible.
13.
30. Oblige, no? Khali oblige.
Item 4,
Item 32 টা 42 টা আছে কি বলবো?
42.
42, sorry.
42.
May please, may
Yes.
please your lordship, call for the said lordship, intermediate quantity and DPS lordship.
Since when he is in custody?
34 days total,
30?
4 days
After vacation will be over or what?
before vacation lordship,
Huh?
before vacation lordship.
After vacation will be after 60 days, Niki.
Lordship,
After vacation will
mandatory period will be over, right? Lordship, we can try on 19th.
19th. 19th, huh? 16 can be. Wait, 16 12. CD.
daily list, item 4,
Madam, this matter will be kindly pass over for timely.
5,
The report has come.
CDS.
Item 5, no?
Written-
Sitting note.
Written told.
Also, yes, case two. Can it be taken up just after some time, Lordship? We'll verify whether CD is available in our office.
Otherwise, on the last occasion, as per the order, CD was received, I think, and it was ordered to retain the CD. You just make it.
Your lordship may kindly take it up on Tuesday next. Tuesday, Tuesday next.
Tuesday next.
No, but we don't know whether it has been retained or not.
But let them take their time till Tuesday next, madam. Today I'm.
Otherwise, it was, as per the order, it was asked to retain the case diary. At present, I don't know whether it is returned or not.
In the motion column,
Yes.
so probably they have not the CD. Then Tuesday, Lordship.
List
If
on
it is
Tuesday.
available, then Lordship may direct it to be retained.
Tuesday is what time?
10.
10 12. List on 10 12 for it. Interim was there, interim be continued till next date of listing.
I'm in the pizza part of matter. That's why I will be difficult to attend it later on, madam. That's why I've taken it on Tuesday.
Lordship.
By the time she will take the instruments.
6,
Yes, Mr. Aslan.
Why it is in motion column কিন্তু no motion column আছে CD করা আছে I
May I
can't
please,
do
your
that.
lordship?
Yes,
Lordship, my senior is having some difficulties. Kindly pass over the matter for the day.
Mr. Purkast. We are fixing it after 1 week, the registry will fix the date because date is not there. In fact, prior vacation, we don't have any dates. So it will either it will be after vacation or it can be after 1 week if it is
It
registered.
be after 1 week.
Okay, we are seeing after 1 week.
Oh, nice.
7,
May please your lordship.
Yes.
Lordship arising out of
You have filed your additional affidavit.
case, my lord, that is there in the annexure A is the order, my lord.
at page 64. Order dated 18/11/24, both sides represented in petition bearing number such and such, filed by the appellant, heard Lanet Council both sides. It is stated that appellant has filed appeal against the order dated 18/10/24, heard both sides. Appellant has failed to substantiate his plea. I don't know, my lord. It appears that taking the advantage of suspension of the order that conviction, appellant is dragging the whole process of law. He is not inclined to abide by the order of court to make payment of 20% compensation. In view of the above, the suspension of order of impugned judgment is hereby vacated. Send a copy of order to the Court of Learned Citizen Principia for information and necessary action. My lord, the stay was granted, my lord. There was no such direction and we prayed for some time because we have some financial hardship, my lord. We are not denied that we will not pay the 20%. We'll definitely pay, my lord. Only we need some more time. My lord, for seeking time, and in the meantime, we have also come against that order dated 18/10, my lord. Before this honorable court, my lord, this has been vacated, my lord. And now, to my instruction, my lord, CGM has also issued warrant against me, my lord. There are two cases. My lord, what I pray, my lord, order dated 18/11/2024, it will be, my lord, annexure A is to be stayed, my lord. And we'll pay, we may be given some more time, my lord. That 20% will deposit in the appeal. And appeal is fixed as at page 64, my lord. 11/12/24 is fixed for hearing, my lord. If I have to pay the entire amount, my lord, or I have put in jail, my lord, in default, but this hearing will be infructuous, my lord, in my humble submission, my lord. I'll definitely pay that. That is never our claim that we will not pay. We need some time, my lord. Thing is that the accused petitioner here in appeal, petitioner here, my lord, he is a dementia patient. His wife is suffering from cancer at Mumbai. She is treated at an elder son's place. We'll definitely pay, my lord. There are two cases, the consecutive 7 and 8 today appeared both the numbers. Here I was directed to pay 8 lakhs, in the other case 12 lakhs.
No, what is the, the compensation amount or the check amount?
In this case, my lord, check amount was 4 lakhs 4,080 rupees.
And your compensation was, your fine was
Fine was 8 lakhs,
double the
double
amount.
the amount. In item number 7,
So you have to pay 20%.
20%.
And what is this order? 1810 is the
18/10, my lord, lordship will get at page number.
58.
Yes. my lord. Thereby, my lord, on that day, I'll read it, my lord. Both the parties are represented, heard Learned Council for the respondent as per for passing order directing the appellant to deposit minimum of 20% fine amount. This court deferred payment of 20% filed its order at the 23/7/24. This was the stay order on 23rd of July. But the appellant has not paid the said amount till date. In view of the provisions of under section 148 NI Act, the appellant is directed to deposit 20% of the fine amount on or before next date. Failure on the part of the appellant to make the payment will lead to vacating the stay order. I have challenged this, my lord, on the ground that criminal courts have no jurisdiction to review its own order, my lord. As per section 403 probably.
No, review will come later on, but the question is that in the earlier order also, there was a condition. The payment was deferred
Yes, my lord.
till some, till
Yes,
a
ma'am.
period, in fact. It was not that it was deferred forever or up
No,
till the disposal of the
No.
appellation, not that. Then it cannot be said to be review of its order, but obviously,
Yes, my lord. My lord, what I pray, my lord, I may be given at least 15 days or 2 weeks time.
till next date only, so it cannot be reviewed. It was the order on 23rd of,
No, my lord. Why I say so, my lord? I have understood correctly, my lord. I'll read that order. 23/7, page 56. My
no,
lord,
your
see,
prayer was the Learned Council for the appellant has prayed to suspend the operation of event so and so and order different till disposal so and so. And it was stayed, and then
also seen the petition bearing number such and such filed by the appellant praying to defer the provision of under section 148 NI Act on the ground of appellant has been facing financial hardship as he has been suffering from various ailments. Considering the facts stated above, payment of 20% of compensation is deferred till next day. It was our petition, my lord, but at page 56, when it was, my lord, in the middle, I will be reading, heard Learned Council for at page 56, my lord. heard learned counsel for the appellant and perused the impugned judgment and order and the memo of appeal, it appears that the appeal is filed within stipulated time. There are sufficient grounds for admitting the instant appeal. Accordingly, the appeal is admitted for hearing. Learned counsel for the appellant has prayed to suspend the operation of the impugned judgment and order dated 24/6/24 till disposal of the instant appeal. Considering the facts of the case, execution of the impugned judgment and order dated 24/6/24 is hereby stayed till disposal of the instant appeal. So while staying, my lord, to my understanding, there was no such condition that 20% has to be, but there was a petition on the next date filed by us taking time on the ground of financial hardship.
Like,
My-
it cannot be held that, but it is more or less like precondition that you pay 20%, stay will be there and 20% has
Yes,
to be paid 148.
Yes.
There are some occasion when it may be reduced also, if it's not a financial crisis, that may be, or waived also.
Waived
That is
also.
the power of the court. But here, your
But
stay
I'm
was
not-
there with the subject to, no, though it's not there, but it's subject that you pay will pay.
I'll
That is
pay,
the
my lord, I'll pay and the hearing, let the hearing be done and this order dated 18/11, not to make, if 18/11 finally, my lord, annexure may be stayed. If a direction, I will pay within, my lord.
in your petition 1811 was not there.
Because, my lord, I challenged that 18th and earlier. And Lordship has taken up this matter on 21st/11. In the meantime, this order was passed. That is why, my lord, that day I was asked to file this additional affidavit. The person, he is, my lord, nearing 72 years of old, probably, my lord. He is an aged person, my lord. And he is, I'm told he is, my lord, suffering from dementia also. But had it been, my lord, medical ground, I am now taking in my petition, my lord. My prayer is, my lord, that impugned order now, my lord, it will be 18/11 maybe stayed, and I may be given some time to pay the deposit at 20%. Let the hearing be conducted, and there a result will say, my lord. And there-
Mr. Pierre Ferma, the learned counsel for the petitioner. First of this is an application on section 528 of BNSS. Praying for quashing of the order dated 18/10/2024, passed in criminal appeal number 23/3 of, bracket of 3 of 2024. Pending in the learned additional special judge in Chukia. However, the additional affidavit, the learned counsel for the petitioner also prayed for stay of the impugned order dated 18/11/2024, which has been passed during the pendency of the present petition. It is submitted by Mr. Sharma that by order dated 23/7/2024, the order of order passed by 23 April. Order dated 24/6/2024, passed by learned CGM Tinsukia in connection with NI case number 103 of 2018, whereby the appellant was convicted under section 138 of the NI Act and sentenced to undergo RI for 6 months and to pay compensation of rupees 8 lakhs in default RI for 6 months, was stayed by the appellate court and stayed by the appellate court, and the payment of 20% of payment of the compensation amount is also deferred till next date of listing. But where is the 28/8 order?
My lord,
28/8 order is again missing.
28/8/2024.
Hmm?
My lord, that entire order at page 57 only. Type copy I have given earlier,
Oh,
down below, handwritten, my lord, in the original.
On 28/8 it was adjourned.
Adjourn, we file petition on, and then fixing it on 18/9/24. That day petitions were filed. And it was fixed for necessary order on the next date, 18/10/2024.
And on two subsequent dates, that is on 28/8/2024 and 18/9/2024, the matter was adjourned considering the prayer of the petitioner. And it was accordingly fixed on 18/10/2024. Whereby the learned appellate court had passed the order asking the appellant to pay for payment of 20% of the compensation amount in default, and with an observation that in default, the stay order will be automatically vacated. First, stay order will be vacated. Accordingly, he had challenged the said order dated 18/10/2024, passed in criminal appeal number so and so by learned special judge so and so. But during the pendency of the said order, during the pendency of the present petition, the learned appellate court had passed the order on 18/11/2024, whereby the stay of suspension of impugned judgment and order, stay order is vacated. Stay order is vacated and copy was sent to the Court of Learned CGM Tinsukia for information and necessary action. And on the basis of which NBW has already been issued.
Yes, my lord.
NBW has already been issued against the present appellant. Stop. Next para, Mr. Sharma further submitted that the appellant could not file the 20% of the awarded compensation amount due to his illness, due to various illness, and also for the illness of his wife who is suffering from cancer. But he is ready and willing to pay the 20% of the compensation amount if some time is given to the present petitioner, and accordingly pray for setting aside and quashing of the order dated 18/10/2024 vis-a-vis 18/11/2024 passed by the learned appellate court, whereby order of stay was vacated. Next para, considering the submission made by the learned counsel for the petitioner, and also considering the fact that the petitioner is still ready and willing to pay the 20% of the awarded compensation amount, this court is of opinion that one more chance may be given to the present petitioner to make the payment of 20% before the learned appellate court. It is fixed on 11/12, so
Yes.
we cannot give, I mean, beyond 11/12, we cannot give, within 11/12 only. Otherwise, we cannot stay it for over, no? Make it.
5 days.
Hmm?
6 of.
Then what to do? You pay for, you take the certified copy of this order. Again, pray sometime, otherwise, because date is fixed on 11/12, we cannot cross it, 11/12.
By next date, lordship will.
Yes, or
I'm
not
sorry
before
to-
next date. It is a time so and so, no? Considering it is so and so. Payment of 20% of so and so. Accordingly, the petitioner is hereby directed to appear before the learned appellate court and to make payment of 20% of the awarded amount on or before the next date of listing. And the NBWA issued by the learned trial court below be stayed oblique suspended till next date of listing. Till 11/12 বা কি আছে ডেট এটা লেখে আর একটু set aside and quash করে দিন. Okay.
I'm deeply obliged, my lord.
Second is Antipas was same.
Same, my lord, only case numbers will be different, my lord. In the second one, my lord,
When orders are dated,
orders are same, my lord. My lord,
dated orders are dated also same.
Same. Same, lord. That is why, my
Here
lord.
also you have filed your additional.
Yes, my lord. There also.
Yes, only difference is
There, my lord, appeal number will be 22 within bracket 3 of 2024.
that will we see. Okay.
And
Or the court is also same.
Court is also same, my lord. NI case number, there it was 103, here it will be 104 of 18.
That will look into,
Yes, my lord.
otherwise same.
Otherwise same.
Okay, both the matters are disposed of. Your NBW issued against you is stayed object suspended and the order dated 1811 and so is still.
I'm obliged, my lord. Deeply obliged.
Both are matter disposed for you.
10,
Applicable. 528 application also there. Challenging the order date. Dated 10/7/2023.
Hmm?
7/10/2023 passed by the learned JMFC. Here Lordship petitioner before Lordship is a junior engineer, is a government servant Lordship. And your Lordship will find the FIR at page 25. The allegation against him. The petitioner who was serving as a junior engineer at that particular point of time. So the allegation is that some misappropriation has had taken place. Your Lordship will find at page 25. 25 of my petition.
Hmm.
Yes, with reference to the subject cited above, I am directed to inform you that Sri so-and-so has not completed 282 number of IOI houses during the year 2009 to 10 to 2011-12 under Pitung Rangthema VDC constituency entrusted to him and thus misappropriated the government fund amounting to rupees so-and-so. And only you were therefore requested to kindly register a case. So a case under section 409 was registered on 16/8/2017 and on 31/8/2023, after 6 years after completion of investigation, Lordship, charge sheet was filed.
CS was filed on?
Yes, on 31/8/2023 under section 409 of IPC. And interestingly, Lordship, even after 6 years, at page 34, your Lordship will find page 34 of my petition, Lordship, serial number 15. Whether prosecution sanction if required or obtained or not, if he has particulars thereof. So this says that no prosecution sanction was obtained. And thereafter, the cognizance was taken without discussing that whether prosecution sanction was taken or required. Nowhere discussed, and mechanically this order taking cognizance was passed by the learned JMFC. The role of the petitioner herein is only with regard to the supervision of the construction of the houses under the IOI scheme. The allegation of misappropriation, the drawing and disbursing officer is the block development officer. So the block development officer has not been charge sheeted. Only the junior engineer is charge sheeted, who is not even the authority to draw and disburse the amount funds of the IOI scheme, Lordship. And the petitioner before your Lordship was serving at the concerned development office.
But you are the FIR name accused.
Yes, Lordship.
Allegation is brought against you only,
Yes,
not against the video.
yes. But this FIR was lost by the video, Lordship. He, in order to save himself, lost this FIR against me, saying that I was the person who misappropriated. In fact, the video is the person who can only draw and disburse the amount or release the funds to the beneficiaries. I cannot release the funds, or I cannot even take the funds. And funds are not sanctioned in my name. In fact, from 2000, the allegation is that, Lordship, the petitioner misappropriated fund and did not constructed the IOI house from 2009 to 2012. I was transferred there at that particular place in 2011, and I served till 2014. So since 2009, the allegation is that I did not construct houses from 2009. How could I construct houses when I was not there in 2009, Lordship? For 1 year, I was there. For 2011 to 2014, I was there. So there cannot be any allegation of misappropriation of fund against me, Lordship. And furthermore, since I am a public servant, 197 says that prosecution sanction has to be taken. And that is not there, Lordship. And in fact, there is a notification issued by our High Court. In view of order passed in criminal petition number 680/2014, a direction was issued to all chief judicial magistrates not to pass any mechanical order while taking cognizance. Serial number B. The magistrate should himself herself write proper order of taking cognizance with proper application of mind and not in a mechanical order. And if your lordship peruses page 36 of my petition, there cannot be a better example of a mechanical order than this, lordship. So this order is also in violation of this notification.
Yes, Bora, please.
At this stage, since the matter has been succeeded, Lordship, and cognizance has been taken, the Lordship may issue notice at this stage, Lordship. We have to go through the reports.
In the meantime, your lordship may pass an interim order because the order taking cognizance nowhere discusses that whether sanction was taken or not. Charge sheet says that no sanction was taken. And since he is a public servant who was discharging his official duty, sanction is required. Must be taken.
Let us call for the case record, Lordship. So notice at this stage.
Heard Mr. R. Bora, the learned counsel for the petitioner, and also heard Ms. S.H. Bora, the learned additional PP, appearing on behalf of state respondent. This is an application of section so-and-so, punishment so-and-so. Issue notice to the respondents, no further formal notice is required to be served on the respondent number 1. Course of the day debut. Next, Bora. Also heard Mr. Bora on the interim prayer. Stop. It is submitted by him that the FIR of the present case was lodged in or lodged on 16/8/2017 by one BDO, and the charge sheet was filed on 31. Charge sheet was filed on
31/8/2023.
24.
23.
31/8/2023. 23 under section 409 against the present petitioner. He, being a junior engineer, his only work is to supervise the construction of the houses under AOY, under IAY scheme. And the BDO is the drawing and disbursing officer, but only to save his skin, he filed the FIR against the present petitioner, and accordingly charge sheet was also submitted. Further, Mr. Bora submitted that from the CS also it is seen that no sanction was obtained by the investigating officer at the time of filing the charge sheet, and the learned trial court below took cognizance by order dated 7/10/2023 in a very mechanical manner without even discussing the requirement of sanction in his order. Mr. Bora accordingly prayed that the further proceeding in connection with so and so may be stayed in respect of the present petition till the disposal of so and so. MS H. Bora submitted in this regard that as case has already been charge sheeted and cognizance has been taken for better appreciation of the matter, the case can copy of the case diary, a copy of the LCM may be called. Okay, stay editable. Where you are going to stay the order till next date of listing, or you take steps for the respondent number 2 within.
Please, lordship.
Eleven.
May I please, your lordship? My lord, this petition is filed for a modification of one of the condition of Zimma order of the learned JMFC Dhuri. Your lordship, the motorcycle is, the Zimma of the motorcycle was granted on furnishing of bank guarantee, your lordship. The petitioner before your lordship is a very poor person, he cannot submit the bank guarantee, your lordship. So the same may kindly be
One
modified.
appeal was also there. You filed
Yes, sir.
earlier appeal.
Against that order
Ah.
for modification of this said condition, prefer one appeal before this session, just your lordship. The same is dismissed, your lordship.
It's under this Cattle Act, Cattle Provision Act,
I don't,
because 11(5) is the
Yes, your lordship. But
Actually, condition of is incorporated in the statute itself, in fact.
your lordship may kindly come to page 10, your lordship, FIR.
No, I have understood that it is a case of
But some provision doesn't attract in this case, your lordship.
does not attract.
No, yes, sir, my lord. My lord, there's some beef was carrying by
Huh?
motorcycle, your lordship.
Beef,
Not, yes, your lordship.
my name beef meat,
Yes, your lordship.
but beef meat also comes under most probably. You cannot, transportation is banned, I think. I have passed one order in somewhere, I don't know. Yes, beef meat also you cannot. But it comes under that act. Now, one thing I want to say, we just, you may not get the relief from this court because I have already passed such kind of order. I have already earlier also have stated. So I was simply listing a list after 1 week. It may be, if you approach the registry, it may be listed before another bench.
Fine.
My view is different. I have already 2-3 matters I have passed the order wherein the prayer was rejected. In fact. That's why.
Bless
Oh, list after 1 week. You
Fine.
approach the registry.
you, bless you.
Item 12.
Let me, Lordship. When not in this case, Lordship, we have challenged an FIR. That Lordship in the FIR, a civil nature of case, Lordship has given a criminal color, my lord. Because there was a business, there was a business transaction between the party. Agreement was there. Authorization letter was there. Lordship, I am going to there. Before that, Lordship, a long FIR, Lordship, I will take your Lordship only the relevant portion of the FIR. Lordship, page 12. Yes, may I read, Lordship? With due respect, I understand back to state that I am the lawful attorney holder of a firm, namely so and so, on so and so, through attorney authorized me to run the business of the said firm as well as to do other analogous work. It is pertinent to mention here in that firm Kamen Engineering basically deals in supply of work or to various institutions under government and private sector. The said firm has its registered office as so and so business are being carried out from the Tinsukia and the undersigned is a resident of Tinsukia. Now, Lordship, next paragraph is important. It is pertinent to mention here that works of the aforesaid firm, Kamen Engineering, so and so also look after by one part-time employee. He is the petitioner, Lordship, namely Prakash Agarwal, a resident of so and so. My lord, here I have been given that I have he has mentioned that I am the part-time employee. In fact, Lordship, I am something different. Now, your Lordship may kindly turn to page 13. I will take your Lordship the middle paragraph. First paragraph regarding that he has then some bank account was opened in the name of Kamen Engineering. Now, Lordship, accordingly, 2 number of works order were obtained by Kamen Engineering Baralumu from Assam Government Marketing Corporation, height number so and so. Your Lordship will kindly note the dates of the works order. 21/1/2016. One is 21/1/2016. Another one is 6/2/2016. Some work is to be carried out by that Kamen Engineering Lordship. Now, executed Assam Government Marketing Ambari undersigned being the authorized attorney holder of Kamen Engineering for terms and conditions here below. On the strength of mentioned to supply order, firm Kamen Engineering supplied so and so bleached cotton hang rank and so dyed cotton arm to various institutions under the Government of Assam Corporation Limited, Ambari since 2006, the 16th till date. Now, Lordship, next page. Against the supply works order, the firm Kamen Engineering, Baralumu in the year 2020, received 2 number of checks amounting to rupees 78,56,657. The check number is given. He has informant has received this amount. Now the aforesaid checks were duly deposited in the bank account of firm so and so maintained by the so and so, and same were credited into it. That means his account was credited. Subsequent to the last pay aforesaid check in the year 2020, the firm so and so carried out the supply work under the aforesaid 2 works order and accordingly submitted bills periodically before the office of the so and so.
that our firm Common Engineering, in spite of submitting supply bills or regular interval in the office of so and so, have not received any payment from the said office since 2020 till date. Considering the same, I undersign on so and so visited the office and inquire about the pending payment of firm, and I came to know that Prakash Agrawal, this is important, allegation has come. Prakash Agrawal and his son Ishan Agrawal collected 4 numbers of check issued in the name of Kamini Engineering from the office of Assam government. Marketing so and so Ambari in the year 2022 and 2 numbers of check in the month of 2024, total amounting rupees 1.73 lakh something lordship. This 4 check, it is admitted fact that I have received this check amount and that amount has been credited in my bank account. Why lordship? That will come. There is an agreement. Since the work of the firm Common Engineering Bharolo is also look after, the whole allegation is that this 1.73 lakhs has been withdrawn by the present petitioner, and this check was obtained from the government. Now lordship, and check number is given in the table. We are not disputing this part. Now your lordship may kindly come to the last page 17. This is the whole allegation made in paragraph 17. The amount is not disputed. Now lordship, page 17. This is the primary allegation against the present petitioner. From the facts stated above, Prakash Agrawal and his son Ishan Agrawal, in connivance with the concerned authorities of the Assam Government Marketing Corporation Limited, Ambari, managed to receive the 4 numbers of payment check of Common Engineering Bharolo from the said office amounting to rupees 1.73 lakhs in total by forging my signature and thereby misappropriate the said amount. Furthermore, Prakash Agrawal and his son Ishan Agrawal, with the help of Madhujo Das, by opening a fake account in the name of Common Engineering, house number so and so, and shipping of the entire amount, and thereby they also committed an offense of money lending. This is the allegation, lordship. This FIR was lost. Your lordship will see the date of FIR, page 12. This is 16/3/2024. 16/3/2024. Against the work order lordship that was issued in the year 2016, and agreement between the present petitioner with the informant that was made lordship in 2018. That is your lordship will find. I have also annexed the work order lordship, page 19. 22.
No, just
This-
tell us, he is the part-time work, he works in a part-time.
No lordship, actually the lordship, the work was lordship allotted in the name of informant. He has entrusted me to carry out the work, and accordingly entire amount lordship finance I have done. And I have
Where is
carried-
the agreement?
Yes, lordship, page 25. This agreement was made on 5th of March 2018 between lordship Common Engineering informant Sondip Garodia. In bold letter, your lordship has filed the first paragraph, and Agrawal and son, situated so represented by its partner Prakash Agrawal, is the accused. But in the FIR, he has not disclosed about this memorandum of undertaking. And your lordship may kindly come to page 26 regarding the work order, these 2 works order. This agreement was made in respect of this 2 work order. Next paragraph, lordship, in middle, and whereas the first party so and so collected total number of work order from Assam government so and so 21/1/2016 and another one 6/2/2016. These 2 works order. And next paragraph, your lordship will find the first party attorney holder being under financial hardship, not able to supply the said material against the said work order by himself alone, has approached the second party requesting him to invest major share of money and supply the said materials under the terms and conditions herein after mentioned. And in the next page, some terms and conditions are given that 40% of the total receipt amount will be received by the informant and remaining 60% will be received by the present petitioner. This is the condition number 1. And condition number 2 is important, lordship.
See, agreement is okay, but the allegation is a bit different because you operated, you received, that is not disputed
Yes,
by
that
you
is
also.
paragraph 2, lordship.
Not disputed by you, but the question is that you created some fake account
Yes,
in the name of Coming Engineering and you had misappropriated
my
this
lord,
one.
paragraph 2 in the terms and conditions that will clear. paragraph to page 27. That the first party, along with this memorandum of understanding, shall also issue an authorization letter in favor of second party for collection of documents to sign, to receive the payment. This is important, Lordship. And to appear before any forum on his behalf. The said authorization letter shall be part of this instant memorandum of understanding. I have been authorized. Authorization letter is also annexed in this petition. And second party, your Lordship, paragraph 4, the second party shall be responsible for supply against the said order. I have completed the work. I have supplied the materials by my own finance. Second party have no representation for anything done wrong by the second party. Or your Lordship will come to page 29. This is authorization letter given by the informant. I, Sandeep Davadia, son of so-and-so, resident of so-and-so, do hereby authorize and appoint Siri Prakash Agarwal, son of so-and-so, near Zonal so-and-so, to collect document, to sign, to receive payment, and to appear
Okay.
before any forum.
Yes,
Now, Lordship, I have.
yes, I have understood what it.
Present petitioner is the part-time work employee, Lordship, at that relevant point of time, and FRA was lost in the year 2024, March, Lordship.
March.
16/3/2024, Lordship. And work orders were issued, that was in the year 2016, Lordship. And Lordship, so far as the
And this memorandum of understanding was,
concerned, that was on 2018. Thereafter, Lordship. This is the subsequent developments. And thereafter, Lordship, authorization letter is also year of 2018. So, Lordship, we have to, at this stage, I'm objecting the interim prayer. Lordship.
My lord,
So,
in
Lordship,
the
may
FIR,
best issue notice to the
the
respondent.
whole allegation is relating there's two works order. 2016 order. My lord, just one.
now
doc-
see, you have submitted that there is authorization letters, memo understanding, we're not disputing it.
My lord.
There may be, but the FIR is lost on 2016 because the
Yes.
question is that you created some fake bank account in the name of the
My lord,
company.
I have.
and
I
misappropriate.
have done, Lordship.
No, authorization is different thing,
My
but
lord.
you cannot create a fake account, na?
My lord.
You are authorized to receive the payment, you are authorized to make the, as a signatory of so and so, but you cannot operate or you cannot create an account. That is the
My
allegation.
lord, just one pair documents, Lordship, page 34.
Mm.
Why, Lordship, he has been filed this FIR, your Lordship will clear page 34. He want to realize the money from the petitioner, that is the letter, Lordship, page 34, last page. This letter was written by the informant to Managing Director, Assam Government Marketing Corporation Limited. Regarding this amount, he is praying for before the authority to give the money to the informant. And when Lordship, the amount is disbursed to the informant, a petitioner, my lord, he has filed this petition. After that, before that, Lordship, I have filed a complaint against them. against the
Okay, we are
informant.
issuing notice at effect. It is not a case to pass any interim order. What is the stage of the case? Is still under investigation?
Under investigation, not yet, Lordship, not yet.
CD call করে দিব, issue notice করে দিব কাল। At this stage, we are not passing any interim. Let us bring the CD, then we'll see to it, because otherwise also it is a criminal petition. So let the other side appear also, because other parties, I'm okay. They have submitted, it's okay. Memo of understanding was there. Authorization letter was also there, but they see the allegation. And your part, you may be correct that after issuing of that notice, when you have filed the complaint, then only he came up with a allegation of misappropriation and then he filed the FIR. That may be correct. But the question is that
These are matter
FIR
of
doesn't
reports,
place.
Lordship. These are matter of.
In the month of March, Lordship, the FIR has been lost, and the work orders were issued in 2016, Lordship. And the memorandum, and so far as the authorization letter is concerned, that was issued in the year
18.
2018. So
These
these
are
are the subsequent developments. So what is the basic, Lordship, thing is that in the year 2016, so whether authorization letter has been issued to him for payment, for collecting payments and all, Lordship. So that is not an.
My lord, everything is on
Let them
record.
appear. Lordship may call for the case study.
Yeah, we all.
My lord, everything is on record. I am not saying anything beyond the record.
Obviously, but the text of the case, you see a bit thing. I mean,
Only to realize.
development and
only to
the
realize
the
money.
work orders and all are issued prior to your And in the year 2018 and work order was the 2000 SCS submitted.
That
But
is in
the FIR is there.
FIR itself, that has a work order has been mentioned. My lord, only
Issue
to
notice
realize the
24.
money.
Yes, case diary can be fixed.
Lordship, Just after reopening lordship.
Just after reopening, immediately after reopening,
Yes.
It's on tenth lordship,
10th of January.
10th of January.
10th of
Notice
January.
In the meantime.
Notice, yes, notice, issue notice.
Yes.
Issue immediately, you notice so that he can appear, and we are calling for the case diary also. এই ইন্টারভিউ দিব না লাগে, বেশি লিখব না লাগে।
30.
আচ্ছা, এটা কথাটো হল কি, মোৰ অলপমান পিছবেলা কাম আছে।
Yes.
So
May
yes,
please, your lordship.
yes,
My lord, here petitioner before lordship is a bank official, my lord. He's a senior manager right now, posted at Patna. What happened, my lord? Complaint. I'm not going on the merit of the case, my lord. There was a complaint, and on basis of that complaint, proceeding was going on. And in that proceeding, I have appeared earlier. I have appeared. Thereafter, what happened, my lord? Pandemic broke down. That COVID. So in that COVID phase, I was transferred to from Guwahati to Ranchi. So, my lord, I had, to be honest, my lord, I had left that some communication gap was there along with my counsel because, my lord, pandemic, actually, my lord, on many occasions, even the court was not functioning and no adverse orders were passed. Finally, my lord, in the year 2021, bailable warrant were issued, my lord. Page 29. Bailable warrant were issued, my lord.
page 29.
To 29, my lord. But I lost, my lord, contact, my lord, that on 29. Thereafter, my lord, it was bailable warrant were issued on many occasions. Then finally, my lord, order I am coming before your lordship is at page 35. I'm not going into the merit of the case, my lord, just 35 is very important that order we have included, my lord. The complainant
Order dated?
order dated, my lord, 1/9/2023.
Yes,
The complainant is absent with step and vice petition number this has prayed for adjournment, showing grounds therein which is allowed. Accused is absent without any step. BWA rupees 5,000 issued against the accused has not yet been executed since 11/1/2002 till date. In order to compel the protection of the said accused, I deem it fit to issue NBW against the accused so that Commissioner of Police Kamrup. The complainant is to take necessary step accordingly. My lord, we are assailing this order only on the count that, my lord, when BW has already been issued and it has not been executed, that first it has to be executed. Then only, my lord, the process would be to issue NBW. Leaving that part, my lord, at this stage, I only pray, my lord, let these orders be recalled. I'll appear at any condition because I am bound to do so, my lord. That is the thing. And on merit, one line only I will say, my lord, allegation is of 2013. I joined the bank on 2017. And even we are contemplating to file a petition for quashing of that. Because on record, my lord, I have joined in 2017 and allegation is of 2013.
you got transferred from Guwahati to Ranchi on when?
I got transferred on 30/8/2020. I joined there, my lord. Thereafter, I was transferred to Patna.
And have you annexed any order wherein from where it can be seen that earlier you were appearing before the court?
Yes, yes. Let me go. Page, my lord, 23. The accused S.M. Madhav has appeared today with his learned counsel with his prayers by petitioner for bail on the bail of the accused person. Hard page the case record at page 23, my lord. Considering the nature of offense and the fact of the accused has voluntarily appeared, today the accused S.M. Madhavan is allowed to go on bail of rupees 10,000 with one surety of life amount in default jail on condition that he will present at the date fixed by this court. And the case is at the stage of copy, my lord, right now. My lord, and his conduct, my lord, he appeared voluntarily at that point of time. On the next date, my lord, I pray that I will definitely appear on the next date without fail. Until then, my lord, this warrant may be recalled, my lord.
Yes, Warren.
That in the year back, that is 11/01/2021, bailable warrant of arrest has been issued, and thereafter it could not be executed. Since lordship 1923, and if it is the bailable order could not be executed against him because he was untraceable. Therefore, NBW has been issued, lordship.
Yes, obviously.
So, from that record, lordship is willing to appear before the trial court and.
I undertake, my lord, I'll be here on any day, even after 27 January is the date, my lord. If my lord directs to appear before that, I will do that.
Heard Mr.
T.H.
Hazarika, the learned counsel for the petitioner. And also heard Ms. S.H. Bora, the learned additional PP appearing on behalf of state respondent. Back eligible, this is an application on section so and so. Mr. Hazarika, the learned counsel for the petitioner submitted in this regard that the present petitioner voluntarily appeared before the learned trial court below, and he was allowed to go on bail by the order dated 13/11/2019 by the learned trial court below. But thereafter in the year 2000, on 30/8/2020, he got transferred from Guwahati to Ranchi and missed some communication with his and his counsel. More so, the case was adjourned by the learned trial court below due to outbreak of COVID-19. BWA, post of BWA was accordingly issued against him in the year 2021, but on 9/1/2023, without even execution of the BWA, the NBWA was issued against him. And due to non-communication with, as he could not communicate with his and his counsel, he could not appear before the learned trial court below, and NBWA was issued in all subsequent states. However, he is ready and willing to appear before the learned trial court below and to contest the case on appearing each and every day before the learned trial court below. If he is, if his NBWA issued against him is suspended of the state. Next para, MSH Bora submitted in this regard that learned court below had to issue NBWA white order dated 1/9/2023 as a BWA has not returned is not returned after execution. No, it is not returned. Is returned. Is not returned as he was as the petitioner was not traceable, and accordingly, no irregularity has been committed by the learned trial court below in issuing NBWA against the present petition. However, she submitted that the accused petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. Within 15 days, will you be able to? Within 15 days? Within 15 days.
15 days, my lord.
Because date is fixed on 27/1.
Yes, long date, my lord.
Long date.
My lord, can it be 3 weeks, my lord? 3 weeks. 21 days.
3 weeks too will be
15
over.
days, it
Three.
can be.
15 days.
Or 15 days, my lord. already.
Yes, because from 19 you are
Yes,
whatever.
yes.
15 days. 15 days of period. Till then, we are suspending your and stay your NBW issued against you.
Deeply obliged, my lord. Deeply obliged.
15.
Timing also, for the timing. My senior is leg on code number 1, my lord, 2, my lord. For the timing. my lord.
16.
May I please, your lordship? Dear application, my lordship. Petitioner before lordship, because one standing NBW order was issued and the petitioner was declared as an absconder. May lordship, may I take lordship to page number 51. Last order. And the case has been closed and kept in a long pending file. May I read my lordship? Accused Mithun Boiswa, at the rate of Tutumoni Boiswa is absent. Page 51. Proclamation issued against him had returned on the previous date after being duly executed. More than 30 days has elapsed since the publication of the proclamation, despite that the accused has failed to appear before this court. Considering the above, it is evident that the presence of the accused Mithun Boiswa cannot be ensured in the instant case without causing unnecessary delay. Further, there seems no immediate prospect of his arrest. Hence, on due satisfaction, the accused Mithun Boiswa is declared as absconder and the case is filed against him until further order. It is thus to be taken off from the regular file and be kept in a long pending register. Issue, next page, my lord. Issue standing NBW against the accused Mithun Boiswa, Tutumoni Boiswa. Lordship, the petitioner is unaware that a case has been registered against him. He is working in Mumbai as a security guard, my lord. I have annexed the certificate, my lordship. That is at page number 53. Since 2000, my lords. 2000 December. My lordship. My lordship, may I take my lordship to page number 14. The FIR. Type copy, my lordship. Even in the FIR, my name is Mithun Boiswa, alias Tutumoni Boiswa, but here one Jitumoni Boiswa. The accused name is Jitumoni Boiswa. Even the police has never tried to reach me. And even they have not served any notice.
Now, see, this is a case where standing warrant has already been issued. We cannot
Yes.
do anything here. It's not possible. You can appear, just we can, your submission can be recorded, otherwise no other interim relief can be given because you have declared absconder, standing warrant is already been issued.
Appear there may be, I may be sent to custody.
Yes, obviously. You should, in fact, you should
Yes.
be sent to custody. In fact.
Sir,
Hiding
also
as
is showing
from
as
the
absconder.
2022 matters, you are
Yes.
absconding like anything.
My
The
lord,
court finding no alternative had to issue PNA that was also written and executed, and thereafter only you are declared absconder and
my
the
lord, sir, I
petitioner.
mean, just a security guard. I was in
You are
Mumbai.
doing security guard. What is the fault of the court, in fact? We can record your submission here, but no interim cannot be given. It's not a case at all. And declared absconder, and that too standing warrant was there.
My lordship,
Now, why you are here?
recently I have came to know, my lordship.
Okay.
Recently the
Could have
petitioner had
absconded
came to-
again.
even in that place, my address, no one is there.
Then how can you come to know now? If no one is there, Ah.
For some of my medical.
no, your family member is not staying there. Oh, then though it's, how can we court bring anything? You're Mr. Fukan?
Yes.
Heard Mr. A. Fukan, the learned counsel for the petition. and also heard MS SH Bora, the learned additional PP, appearing on behalf of state respondent. This is and so and so. It is submitted by Mr. Kokon that the present accused petitioner was not aware about the pendency of this case, as he was working in where he was Mumbai as a security guard since 2020.
Since 2020 months.
Since 2020, and in that regard, one certificate is also issued by the company wherein he was working. He recently, when he returned back to his place of origin, he came to know that the case has been pending and the warrant is already issued against him. And then obtaining the certified copy, etc., he came to know that he already declared absconder by the learned trial court below, issuing after issuance of the PNA proclamation, and the case was kept in the long pending file by issuing a standing warrant against him. Post-op. There was no negligence on the part of the accused, not part of the accused petitioner, but as he was not aware about the case and police never searched for him, he and no, not about okay, submitted that as police did not search for him from the date of filing of the FIR, he was not aware about dependency of this case against him, and for this only he could not appear before the learned trial court below. He is ready to appear before the learned trial court below if the standing warrant issued against him is stayed or suspended till his appearance before the learned trial court below. Next, MS H. Bora, the learned additional PP submitted in this regard that the accused petitioner was absconded. You are also showing as an absconder in the charge sheet?
Yes, absconder charge sheet.
Yes, showing as an absconder in the charge sheet as he could not be apprehended during at the time of investigation, and issuance of and after several and the court took every endeavor to procure his attendance, and finally the PNA had to be issued and declaring the present accused petitioner as an absconder. She accordingly submitted that the petitioner may be directed to appear before the learned trial court below, but no interim relief can be granted to the present accused petitioner. May not be granted. Next, hearing this submission made by the learned counsel for both sides, and on the considering the conduct of the accused applicant, and also considering the endeavor made by the learned trial court below, I find that the petitioner is hereby directed. This court is the opinion that no interim relief can be granted to the present accused petitioner. However, he is directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. With that observation, the absence is disposed. Okay, you appear. I have already recorded your submission here in this case. It may help you some way, I don't know, but.
Possible.
17.
Yes.
In this case, Lordship, it is charge sheeted case, Lordship, and earlier he was arrested, Lordship, and the learned trial court, Lordship, and issued summon, but summon was not served to the petitioner, Lordship, until till date, Lordship, and subsequently, Lordship, LBW has been issued against him, and kindly, Lordship, for your kind attention, kindly come to page number, Lordship, 17, and operating portion start from page number, Lordship, 19, Lordship, top part. The arrested accused person, Lordship. And this is the charge sheet, Lordship, and already been arrested the serial number 4. And Tultul Rava, so and so, number 2, Sukleshwar Rava, so and so, number 3, Kogen Roy, so and Vitura Sutia is a present petitioner, Lordship. And Lordship, and we'll find, Lordship, page number 24, Lordship. Page number 24. This someone issued to the accused Tultul Rava has written with report that address falls under so and so, and someone issued to the accused Rituras Sutia has written with report that his address fall under PS so and so. And someone lordship so and so, and accordingly lordship, on that day lordship the next page lordship page number 25. The someone was issued lordship, and then subsequently lordship NBW issued lordship, and now lordship, and he is ready to appear to the court below lordship. Only few days lordship protection may be given lordship. Otherwise, earlier he was arrested and subsequently charge sheet was submitted, and no summon was served. And even then lordship NBW issued against him lordship, neither police or any other person lordship visited his house lordship in connection with the summon or NBW lordship, and he is residing in a joint family lordship. So, my lord, little protection lordship only he will be appear lordship, and next date fixed on lordship. 21/12 lordship. This month. Earlier arrested lordship and released on bail. Any condition may be
Okay, earlier arrested, released on bail. Why didn't you appear?
lordship, and now NBW is there lordship.
Yes, NBW is there.
Lordship.
In the earlier occasion, why don't you appear?
No
Why
lordship.
didn't you appear?
Lordship, someone subsequently after submit at the stage of during the investigation stage, I was arrested. Subsequently, charge sheet was submitted lordship.
Yes, obviously. Thereafter, summons were issued to you.
No summon, I have not received any summon lordship, and the order itself is very much clear lordship.
Ah. But you have not annexed the other orders, no?
Sir, other similarly lordship and all lordship and volume of them, they are big lordship, and that is why I have placed order lordship and next lordship. But it is sequence is their lordship. Kindly come to this 24. 24 only summon is issued against me, and lordship subsequently and last order, and 21 lordship, that is the notification of COVID-19 in the year of 2021. And lordship,
No,
page number
you're
28
saying
lordship.
24, obviously it is
All-
written that
all
someone were not
only
issued.
Issued lordship.
No. 24, it is seen that address is not proper, so
Not
summons were not issued,
Not
I mean,
issued.
served on him.
Lordship. Otherwise, someone is
Thereafter,
judicial.
where is the order? Because on that day only, BW were issued on Suklesar Rava,
That's it.
Suklesar Rava only, not against you.
No, lordship.
Then,
Order is very clear, lordship. May I read lordship once
no,
again?
it's very clear. It's not issued against
So on
you.
the someone issued lordship, and on that day lordship also issued someone lordship, and subsequently lordship kindly comes to page number 25.
25 also summons were also.
Also
okay,
someone issued lordship.
Yes.
That
So
was
very nice.
someone issued, and only NBW issued lordship. That order will find lordship page number 28.
You
Lordship.
place all the order sheets, list order sheets.
Lordship.
List, it is for you. When your date fixed is, next date is fixed on
21/12
21/12.
this
We
month.
don't have any date now then. File an additional affidavit, furnish all the,
On 10 lordship, I'll find lordship. On 10.
no, that is not possible. Well, I was gonna say, but it not, the date is not there in fact. Obviously, after vacation we'll do.
NBW issued, so before vacation, any date I will find. Only 3.
You are saying before vacation, we don't have any dates, that's why. 12 give us any. Check it.
11.
List 11, petitioner is hereby asked to file all the order sheets in a, by additional affidavit.
Obliged, lordship. Obliged.
So, what the order?
Timing 4.
Yes.
Here in this case, Lordship, my Jimma petition for seeking Jimma of Betel nuts was rejected, Lordship. Against that order, I am before your Lordship. Lordship, may I
Where is the order of the land court?
court order dated, Lordship, page 24, Lordship, dated 18/9/2024. Page 24 shows, Lordship, that initial charge sheet was submitted on the same day, and later on, Lordship, will find page 25.
Option sale prayer was also there.
Also there. Initially, I was visiting the lordship, concerned PS, but the investigating officer was not taking my documents, lordship. And thereafter, lordship, what happened? I sent those documents from by post, lordship. That your lordship will find at page 20. As he was not receiving those documents, I have to send it from post, lordship, page 20.
KG is 11,430 kgs.
Lots.
Now, what is the present position? It is at
Present
page
position
9.
is charge sheet is submitted and the articles are still lying in the police station, lordship. And page 19, your lordship will find those receipts are there. And FIR says, lordship, the vehicle was kept in abandoned condition in the highway. It was not kept in abandoned condition. It was parked there because I have to pay the GST bills and thereafter the vehicle can move, lordship. It was sent to, it was sold to one Sanjit Ghosh, that your lordship will find page 19. And my husband went to the office for depositing the tax amount. And when he was lordship, going to Dhubri district, he was apprehended by the police that you are the owner of the truck, so you are arrested now. And thereafter, when lordship, this petitioner lordship wanted to submit those documents before the investigating officer, he did not receive any documents from her. Thereafter, she
I mean, during investigation, you could not produce anything, any documents.
but he did not receive. Therefore, back going under compelling circumstances, I have written this letter at page 20, what I have placed before your lordship, that I am the owner, describing all the facts I have stated before him. But so thereafter, lordship, on page 24, he submitted charge sheet and also prayed that owner is not coming up, so I may be allowed to auction. And the learned trial court, what I understand from the case, lordship, that hold that there was no GST payment bill or other documents, therefore he allowed the prayer of the investigating officer. And second ground, your lordship will find page 26, last paragraph, that report of the forensic expert that it is not fit for human consumption because of that, lordship. And there, although
FSL report was there, obtained.
FSL report was there. And lordship, although it was, lordship, may kindly say page 26, last paragraph. May I read, lordship? The petitioner has also furnished, failed to furnish any document which justifies her claim that she is bound to transport the seized article to Sujit Ghosh of Falakata, West Bengal. In addition to this, the verification details report of Assistant Commissioner of State Tax, Dhubri, reveals that the seized vehicle bearing white registration number so-and-so white, which the seized articles nuts were transported. Here not transported. In the FIR, lordship will find that vehicle was kept in abandoned condition. Yes, it was kept in abandoned condition because we have not paid till that point of time GST. Therefore, it was in abandoned condition. Had no valid tax invoice or e-way bill in respect of the transported nuts. Further, it appears from the food analysis report that the seized Areca nuts are not fit for human consumption. And in this regard, the Jimma petitioner also failed to assure this court that the Jimma of the seized Areca nuts is that in case the Jimma of the seized Areca nuts is granted to the petitioner, then the petitioner shall use the same only for the purpose of industrial use and not for human consumption. In this regard, lordship, I would like to submit one division bench judgment of our High Court, which says, in case of lordship, seizure of betel nuts, lordship, if it is found for not for human consumption, that lordship, court cannot reject the Jimma of that, lordship. Lordship, may kindly see one aspect, lordship. Last paragraph, lordship, last page, lordship. Point number 15 and 16.
Yes, 15 and
15
16.
and 16. Coming to the point of quality of the seized betel nut, it is reflected from record that immediately after the seizure, on examination by scientific experts, the goods were found to be fit for human consumption.
However, in the second test conducted after almost 7 months, the same goods were found not to be fit for human consumption. If that be so, it cannot be a concern of the custom authority to assail the decision of the tribunal on the ground that tribunal ought not to have set aside the order of confiscation, inasmuch as from the record itself it is established that the goods seized become unfit for human consumption during the period they were under seizure. 16. If the confiscated goods are used for human consumption after its release, the same will give a different cause of action for different authorities to take action against those persons in accordance with law, and it cannot be within the jurisdiction and concern of the customs authority. Accordingly, the substantial question of law is answered against the appellant and in favor of the respondent. So my submission to your lordship is that the SOP which is there, lordship, that SOP says that I have to give an undertaking before the SP concerned. And if I violate any of the terms and conditions or undertaking, then different cause of action will come. For that, my Zimma petition cannot be rejected, lordship. And another
But
different.
the satisfaction of SP is also is to be there. In fact,
Yeah, the trial
but
court.
here in this case, whether there was any such
No, the trial court did not ask me to submit any undertaking before the SP. Straightway, lordship, that line is written, lordship, just I have pointed out. The seized areca nuts are not fit for human consumption, and in this regard, the Zimma petitioner also failed to assure this court that in the case the Zimma is, so I cannot satisfy that court. I have to give undertaking before the SP, lordship.
yes, Bora, Nitin.
That regard, we just need a report whether this seized areca nuts were the subject matter of confiscation. We just need a report to that regard.
Obviously, at this stage, we don't have any other, we have to call for a report first. Now, as per him, it's true, it is a option was there, but the question is just still lying in the custody of so-and-so. So you want to say that report on?
6 articles were subject matter of confiscation. That report, or do we need that report?
No, already report was called, and the auction proceeding is already stayed by this honorable court.
It is a subject matter of confiscation proceeding at this stage. If it is not, then
It is not confiscated, only they paid for auction sale, lordship, and that order is stayed. That order, your lordship already seen, that page 27, lordship will find that auction sale was allowed, pair of auction sales, and which was which was stayed by this honorable court in the.
Where is
present-
the order? Stayed by this court?
Yes, in the present proceeding, this is stayed, lordship.
It says there in
Yes.
present proceeding.
Yes.
1809.
Oh, acha, so stays there.
Also, another judgment, division bench judgment of our high court is there, that if they say it is Burmese supari, then Customs Act will come. And if Customs Act comes, police have no jurisdiction to seize those articles, lordship. Just I am relying on that, paragraph 24 and 26. Because in the report also, they have not categorically said whether it is lordship of Indian origin or it is from Burmese supari. Paragraph 24 and 26.
Okay, then it has already been, as it has already been stated. Now, what kind of reporting will be the option is there? Of confiscation, we don't know whether there is any process of confiscation was there or not. Or as it is already there that it is not it's not fit for human consumption. So there are some formalities as per the SOP. Now, first we want to call for the
When the order itself is at page 25 only. Page 27.
yes.
It's 11/2024 weeks for submission of compliance report from the IO. Whether that report has been submitted, so we also need that compliance report.
So prior to that, this stay order was passed. This was fixed on 4/11/24 and interim order was passed on 25/9/24.
25/9.
9/24. After 2 months, this date was fixed. That was already stayed. No compliance report can be submitted if stay order is
Let us
there.
call for the report, Lordship.
And already on last
Along
2,
with
3
the
occasions, lordship, in the report was called, lordship. Lordship may kindly see the last order.
Is not before us. That compliance report was called for, that is not before us. So we need that report.
No, if-
You want to say whether any compliance report was? But he is submitted that the compliance may not be there because stay is already
there. I
there
have
on
already
25/9. 25/9 itself, the stay is already there. So compliance may not be there.
25/9/24 already comprehensive application login body.
Okay, we call for it now. At only is the status report, whether there is still lying and all. And whether if any compliance is submitted in regards to auction only, because confiscation proceeding was not there, I think.
If I may, Lordship, Lordship may fix it at 2 or after some time. She can call from the investigating officer whether it is lying.
Ajay, it's not possible.
Because Lordship, that it is pending since May, Lordship. Those articles are kept lying, Lordship.
It's
Not
only for
possible.
question, Lordship, so there is no hurry. So we need some time to produce the same.
And already number of times they were afforded, granted time, Lordship.
No, no.
for
Number of
obtaining
times?
Yes, Lordship, may kindly say the last order also. Lordship has granted me short date only because of that reason, that the articles are lying since long, Lordship. Lordship's order is their last
I
order.
cannot say, but it is 2 dates has already
Yes,
gone.
only 2 dates,
25 is the first date where
Yes,
he
yes,
got the stay order,
yes.
and last date is of 28/11.
Yes.
So wherein the interim was continued, in fact. 29/11, you have already sent your information, intimation. But till now, you don't have any
Lordship,
instruction or
no,
intimation
no
from the,
instruction till date.
then when do you want to fix it? When do you want to fix
But
it?
any date as per the convenience of the court.
Also ask for one, whether,
So let it be on, let then Lordship on.
one,
7th.
no, as per SOP, whether there is any, I mean, we don't know whether the SP has taken any steps or there was any communication with DSP and all.
No, that-
For that, we don't have anything here.
No, that comes only if court allows my Jimma application. That SOP I have enclosed, that your Lordship will find page 28.
Status report.
Only status reports. Status report la call kori dibo. You communicate, because on the last day also he rightly submitted, Mr. Goswami was asked to personally communicate with the concerned IO, in fact. In spite of that, most probably have not received the notice. No, because we are giving you one more chance. For this status report, call for personally intimate and try to get it. But regarding the date is another problem. We don't have any dates, Mr. Ahmed.
Otherwise, Lordship,
If you agree, then immediately on 3rd of December only working, or sorry, 3rd of January can be, otherwise,
before vacation, any date, Lordship.
before vacation, we don't have
No,
any.
otherwise,
dates.
Lordship, those articles are decaying day by day, that your Lordship is know.
Now he is insisting.
Positively on 3rd.
I have nothing more to submit, only their report will do, whether that is there or not.
Okay, 19 Koido Praiboni. Last 17. 17,
Lord.
okay, 17.
Problem.
Report group status.
17th for report, Lordship.
Yes, status. Report.
Lordship, on the last occasion, Lordship will just bring the last order, Lordship.
Last?
Last order, Lordship.
Huh.
His petitioners, Lordship has called for the up-to-date status report. Petitioners are in custody since Lordship 15/11 from the date of their arrest. They were arrested on 15/11. And subsequently, charge sheet was submitted on 16/2/24. And charge was framed on 1/4/24. And charge under 21C and 29 of the NDPS Act. Lordship. And evidence stay started from 22/4/24. Till date, Lordship, not a single witness has been examined. And
They got arrested on
15/11,
23.
23.
CS?
CS on 16/2/24.
Charge is also framed.
Charge is also framed and
Charge when framed.
1/4/24.
No witness.
Two grounds, Lordship.
Hmm.
One is long incarnation, Lordship, and the other one is delay in trial, Lordship. And there are many judgments, Lordship, even the apex court. The number of cases has granted bail, Lordship, in these two grounds. Lordship. Because one hand, they are keeping me in custody, these petitioners, and on the other hand, they are not proceeding. And if Lordship will come to page 21, Lordship, the list of witnesses, Lordship.
21.
21, a list of witnesses. I think most of them are police personnel, Lordship. And it is not that the trial has begun after a long gap, Lordship. Even after that, Lordship, the witness has not turned up. It will take some time, Lordship. Completion of the trial. On that ground, Lordship, petitioners may not be detained, Lordship. Their liberty should not be curtailed, Lordship. I am giving some judgments, Lordship. Lordship is already aware about this judgment, Lordship. Yes, sir. One is the, Lordship, is Ravi Prakash case, Lordship, as a state of Odisha, Lordship.
Hmm.
Yes, Lordship, there, para 3, 4, and 5, Lordship.
Hmm.
We are informed that the trial has commenced, but only one out of the 19 witnesses has been examined. The conclusion of trial will take some more time. As regards the twin conditions contained in section 37 of the NDPS Act, the Learned Counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition's reformation of opinion as to whether there are reasonable grounds to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent some more than 3.5 years in custody. The prolonged incarnation generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b)(2) of the NDPS Act. However, we find such some merit in the contention of the Learned Counsel for the respondent state that the petitioner, being not the resident of the state of Odisha, some stringent conditions are required to be imposed upon him. Consequently, while directing the petitioner shall be released on bail on furnishing bail bonds to the satisfaction of the trial court, it is directed that he shall be required to produce 2 local sureties, since he was not from that state. So he was directed to produce 2. And the second one, Lordship, Muhammad Muslim, Lordship. That is also in that order also, Lordship, in para 11, Lordship, para 12, and 13, Lordship, the second part, Lordship. That is discussed, one case is discussed, Lordship, that under the Unlawful Activities Act, para 14 of that judgment, Lordship. Lordship may come to internal page 6, Lordship, page 6 of the judgment, Lordship.
Yes.
Yes, that para 14 of that, Lordship, in second paragraph from the top, Lordship. In the recent decision, while considering bail under the Unlawful Activities Act Prevention, this court in Union of India versus A.K. Najib observed that even in case of special legislation like the Terrorist and Disrupt Activities Prevention Act 1987 or Narcotics, Drugs and Psychotropic Substance Act 1985, the NDPS Act, which too have somewhat rigorous conditions for grant of bail. This court in Paramjit Singh versus City of Delhi, 1999 SCC 252, Baba versus State of Maharashtra, and so, the enlarged the accused on bail when they have been in jail for an extended period of time with little possibility of early completion of trial. These are the observations made, and in this case also bail was granted, Lordship. And next one, Lordship, our High Court, Lordship, that order, Lordship, bail application number 364 of 24, where if Lordship comes to page 10, that these two, Ravi Prakash and Mohammed Hussain, is discussed, Lordship, dear. And from 28, Lordship. From 29, Lordship, page para 29 of that judgment, Lordship. Various judgments are discussed, Lordship, here. Only on these two grounds, Lordship. And recently, Lordship, there's a very short order, Lordship, of the Honorable Apex Court, Lordship. I have given that order also. There also, Lordship, on this ground, bail has been granted. So my humble prayer, Lordship, since there is no possibility of starting of the trial or completion of the trial at the earliest, Lordship, so they should not be detained, Lordship. It is my humble submission, Lordship.
In my humble submission, I wanted to state that, Lordship, it is not that police officers are only interested witnesses, Lordship. It is not that. Moreover, Lordship, the cases, charge has been framed on 1/4/2024, Lordship. While considering the long incarnation, Lordship, it has to also be considered how many number of courts are there, Lordship. It has to be considered on the some benchmark has to be there, Lordship. It needs to be considered. Moreover, Lordship, it is on next date is 9/12/2024. On other occasion, except that, Lordship, still the date has been given. Witnesses not appear, Lordship. They are the, Lordship, the police officers or so they cannot come because they are on other duty. It may be, Lordship. So I think, Lordship, updated papers may be called for, Lordship.
It was updated, citizen was.
Yes, on the last occasion, Lordship has called for. That was the submission on that last date occasion also, Lordship.
But I only
And today they have making the same submission.
I also wanted to state here, Lordship, whatever the case clause has been given, Lordship, it is not that it is only after 1 year has gone and has been given. If my friend can show that, Lordship, after 1 year it has been given, Lordship, a balance has to be taken, Lordship. I'm not stating that we are on fall, Lordship, but it is not that, Lordship. It has to be a balance, Lordship. Interest of the society also taken into consider. Yes, it is interest of the accused is need to be considered, Lordship. 21 is there, Lordship. I know that, but still, the number of the courts, how the case is pending, Lordship, it needs also to be considered, Lordship. It has to be reasonable, Lordship.
By imposing stringent condition, Lordship, they can be granted bail if they will appear and face the trial, Lordship. That will, if they default, Lordship can put a condition, the bail may be rejected.
Next day is, Lordship, 9/12.
Yes. Lordship is disposing of the application.
We'll dispose it.
Order is reserved.
No, I'll pass the order today itself. May not be come off because I have other works also, but today I will pass it.
46.
I have list.
May it please your lordship.
Yes.
my lord, this is an application under section 483 of the BNSS, your lordship.
Hmm.
What happened, my lord, the petitioner was picked up from his house, my lord, arrested on 1610. What's it may no note, my lord, 1610.
1610 of 20.
1610-24.
20.
1610-24, he was picked up from his house, my lord. Then, my lord, he was, my lord, as per my instruction, he was taken to an isolated place, my lord. Before coming to the FIR, I'm just stating the facts, my lord. In near Pukunari, my lord, Pukunari Tea State, he was taken to an isolated place. Then he was shot on his leg, my lord. And then he was brought to the Dibrugarh Medical College. And one of his right leg got amputated, my lord. He was under treatment. Now he is sent to judicial custody. He was under treatment. Your lordship may kindly see. Then, my lord, the arrest memo as page 18. Page 18 is the arrest memo. Page 18 is the arrest memo of the petitioner.
Yes.
My lord, here, my lord, it is on 21st only. It is only on 21st. Is my lord, the date and time of arrest is 20. That is after lapse of 5 days. His my lord, that was after his leg got amputated. My lord, then my lord, he was arrested without assigning any reason in the arrest memo. Lordship knows, my lord, there are judgments, my lord, which are going to place, my lord. Lordship knows, my lord, without assigning any reason in the arrest memo. Now, my lord. Now coming to the facts of the FIR, my lord, the FIR, my lord, that is at page 12. The FIR does not disclose any offense, my lord. Only thing that they were planning, my lord, to my lord, conduct some activities, my lord. But there is no space that they have done something or they have, my lord, abducted someone. My lord, there is only one, there is in the below line that they have failed to do one abduction, my lord. That is the allegation against, my lord. Them and one person.
I mean, they were preparing to abduct someone.
Well, that is the
As part of the allegation.
As part of the allegation, my lord, and my lord, but this is the allegation. They were, my lord, they were planning to demand money. Planning, my lord. Nothing has been done. Now, my lord, lordship may kindly see the forwarding of another excuse where I got that he was picked up on 16. That is at page 16. Page 16, your lordship. Kindly see page 16. Third paragraph. At the earliest hours of 16:10 to the 24th, so and so were detained from his residence, my lord. He was picked up on that day.
Who is the other
No, this accused.
Oh,
my
this
lord.
accused.
That's why I'm showing, my lord. He was picked up on 16 and he was shown arrest after his leg got amputated, my lord. Now, my lord, he was under medical treatment at Dibrugarh AMC, my lord. Lordship may kindly turn to paragraph page, my lord, 46, my lord, 45 and 46, my lord. These are the photograph which clearly portrays, my lord, that his leg, my lord, got amputated. Page 46. His leg got amputated, my lord. Now, my lord, regarding his custody, my lord, he is facing, my lord, lots of hardship in the jail now, my lord, with one leg, my lord, fresh wounds. Recently he is operated. He was operated, my lord. And he has got, with one leg, my lord, it is very difficult for him to pass days in the jail, my lord. And with, of course, with fresh wounds. And moreover, I would like to place a judgment if lordship knows, my lord. I'm relying only just on 2 paragraphs, your lordship. That, my lord, the arrest memo should assign reasons. That is paragraph 19. And 29. Paragraph 19, lordship has got it.
Yes.
Resultantly, there is no doubt in the mind of the court that a person arrested for the allegations of commission of offense under the provisions of Unlawful Activities Prevention Act. Here also arrested under Unlawful Activities Prevention Act. Or for that any other offense has a fundamental and statutory right to be informed on the grounds of arrest
in writing, and a copy of such writing grounds of arrest have to be furnished to the arrested person as a matter of course and without expecting at the earliest. The purpose of informing the arrested person the grounds of arrest is statutory and statutory inasmuch as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody remand, and to seek bail. And any other interpretation would tantamount in diluting the sanctity of the fundamental rights guaranteed under Article 22(1) of the Constitution of India. Then, madam, on page, paragraph 28 and 29. 29, I'm reading, madam. Top paragraph, Lordship.
Yes.
Hence, we have no hesitation in reiterating that the requirement of to communicate the grounds of arrest of the ground of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22(1) and 22(5) of the Constitution of India is sanctioned and cannot be breached under any situation. No compliance of this constitutional requirement and statutory mandate would lead to the custody or detention being rendered illegal and cause and the case may be, my lord. So, my lord, here, my lord, when he was arrested, my lord, no, my lord, the arrest memo was given, and moreover, my lord, this FIR was lodged on at 2 a.m. when he was picked up. He was picked up at 2 p.m. for 16. Then, my lord, this on FIR was lodged on that. So, my lord, may I pray, my lord, when there is no offense committed, and he was arrested on 21/10, my lord. So, my lord, and one leg, my lord, he is with his, my lord, facing lots of hardship, my lord. He has a family, my lord, a small boy, my lord. So, considering all these aspects, my lord, I pray, my lord, at this stage, my lord, his detention may not be required further, my lord. So, no offense as of now has been committed, my lord.
Made a conspiracy to have kidnapped one grade 1 officer for demanding money. And they have, in the meantime, they have arrested by the police, and from the statement of that arrested this person will be detained, and during that time he was shot and now he is in medical treatment in JMC.
Now in jail, my lord. He is taken to jail, my lord.
The statement of the co-accused, which were arrested by the police, this person was arrested also. The petitioner was arrested. The petitioner is Sander Alpha Catalog.
From 16, it will be, my lord, one or 2 days, more than 50 days in custody. He under detention, my lord. So, my lord, there is no offense committed on any stringent condition, my lord. One leg he cannot, my lord, move, my lord. His condition is not that good. I mean, he's a human being, my lord, facing lots of hardship in jail. Natural calls are there. One leg, my lord, is facing lots of hardship in jail now, my lord. So no offense has been committed till now, my lord.
And they have planned to make, they have conspired to make it.
But it was failed. The FIR it is failed, my lord. Condition, my lord. He is a local resident of Sibsagar only, my lord. Moran, my lord.
The procedural part, but in the arrest memo is here, but that part is not here.
Arrest memo, my lord. It is the lordship knows, my lord. That's what the grounds would be assigned, my lord. No grounds were assigned.
Then UAPA Act, lordship, case under register under UAPA Act, lordship. Other things, I have received the case by and the co-accused statements were also recorded. In the statement, from the basis of the statement of the co-accused, he was arrested. Lordship.
No, as per you, whether the other further custody interrogation is required or not.
That for everybody is arrested, lordship. That part is not here.
Is there any note of the IO?
For the IO note, lordship.
Lord Dorothy puts condition, my lord, on every fortnight I will appear, but my jail man are making lots of hardship.
Only thing I was praying that the consider the prevalent security schedule of the state and the interest of the case. I request submit prayer of the court to effect the Rahul Hazarika. He's in now ongoing treatment of under AMCs. So.
No, that is different. He was not under treatment at present.
At the report received at that time of, now he's in jail side.
You received this one
27/11/24.
earlier.
20 years the IO prayer of 27/11/24. That's why this is.
But from mother, there no offense committed till now. Only there was done as per allegation, there was a planning. And my lord,
Of 500 into CD.
It's a very voluminous CDC or CD, if anything is there.
Very voluminous. Statement of the accused co-accused worksheet is 28 pages or 30 pages.
on my ground is the arrestment also, the main ground. No, this one is nothing has been uttered by the police. Why I was arrested in the arrestment. Lordship knows that this is a condition precedent, my lord. That reason should be assigned, my lord, why I am arrested.
After this.
Detention লাগিব কি কৰি এখন ভৰি ৰাখি আৰু কি কৰিব নোৱাৰো.
That part I leave it to the lordship, but my objection may be recorded in this regard.
No, I'm just could not follow you. What is your objection, in fact? You're just saying that statement of the co-accused recorded,
Yes.
and at that part, what is your
That part,
objection?
lordship, he has involved, he was associated with them, lordship. When the conspiration was made, lordship, but they have failed. In the meantime, police arrested all those persons. On the statement of the co-accused statement, he was
The conspiracy was to kidnap whom?
kidnapped a senior grade ONGC officer and demanding money, and he was sent over to the Alpha lordship. That was the allegation, lordship.
Alpha? Alpha means what? What kind of conspiracy was there? Na?
For demanding money, lordship. Kidnap and demanding money. They made the conspiracy. In the meantime, they have failed to do so. Police arrested them. With Mr. stating that he was along with them. The petitioner was along with them.
What about the status of the other co-accused persons? Have any idea?
All are in the jail.
All are in jail.
Lordship. Prison person, lordship.
POP is not 90 days, I think. It is 180.
It may be.
If you have any time, because it's voluminous, if you want to have any, want to reduce this one,
Yes, sir.
we can fix it after some time.
So only thing is that their allegation is police during investigation, that police find that these persons who were arrested, they were linked with some alpha cadres. This is the allegation, lordship. And he was associated with them.
If linked with alpha cadres, then obviously UAP will come, no?
Then lordship, one thing is there, during interview, it also reveals that conspiracy was led by some one alpha cadre. Mainly there was, he was not. This apprehension is only the that he was a former alpha cadre, under alpha cadre, that's why he was in there, and that statement also said that he was along with the conspiracy. With the co-accused.
Reflects any grounds of arrest, my lord, why he was arrested.
That part is here, go ground is not shown in the rest is here.
So your ground is arrest memo and he is facing some problem.
He was taken into consideration, 21, he was. No offense as of now has been committed, my lord, as per the allegation also, my lord. There were, as per the allegation, it is alleged that, my lord, some, my lord, conspiracy was there in the FIR. It itself is reflected that it has been, it is failed, my lord. And my lord, in the arrest memo, he was arbitrarily arrested, my lord, without assigning any reason. 16, he was taken into custody. 21st, he was, his my lord, younger sister was given an arrest memo, only an arrest memo, my lord. And my lord, now, my lord, his leg got amputated. He was in, my lord, AMCS for under treatment. Now it phrase, he was dragged to the, even the learned, my lord, when he was produced, my lord, the condition, seeing his condition, he was not given any police custody.
Was there any prayer for further custodial interrogation in the jail premises itself?
Custodial interrogation is that some phone number was placed, they have to have had to for serial analysis was not at present available, lordship. That is remaining, lordship. So
Lordship may put any stringent condition, my lord. I will appear, my lord, before the investigating agency, my lord, every week or, my lord, every fortnight, my lord. But, my lord, my bail, my lord, at this stage, my lord, we're facing lots of, because, my lord, in jail, my lord, with one leg amputated, my lord, with very much problem I'm facing, my lord.
Son of Saboli City. Or pass your.
Or lordship, oblige your lordship.
86, for bail hearing.
no, it was not gone for yet, lordship. So after some time, lordship.
Oh, you're still busy.
So lordship, another date, lordship, I have some problem, lordship. Supposed to go.
Till when it can be retained? He has some other,
Lordship, I have some to. Supposed to
he has
go
some
home.
other engagement.
If possible, other.
You,
56, lordship, I have gone through.
okay. No, you take time. It's okay. No hurry is there. He is saying that today may not be possible for him in the at 2. That's what only.
One way, lordship.
Monday দিব পাৰিব। Monday may not be possible. Monday, Tuesday, lots of matters are there. Maybe on 11th. Till 11th. CD receipt due to and the request made by line counsel for both sides. That is adjourned. CD receipt. Retain the CD till next date of listing. List on 11th. Okay.
57,
Out of same city, lordship.
So out of same.
Yes.
Now, out of same city, she is actually confusing. It's not yet completed. The other, Mr. Hawk is taking all the time. So we may fix it on 11th.
Of this one,
11, this Wednesday.
Tuesday.
This Wednesday.
Tuesday,
Wednesday.
Wednesday is 11th.
developed.
Same order. Huh? Is out of same FIR.
Timing 15.
What nature of case this one? EPS, I think. That. No, yes. It's here. Oh, he mattered. I'm really fed up with taking this matters. Karakana sweater matters. Silly, upon from tool, but I see more than from tool. That is the case. Already there is sufficient progress. So we used almost near about 19. We have already released one day. Yes. when
May I
was it?
please, Your Lordship?
50.
15.
1 5, my lord.
Oh, 15. Achha.
Motion, my lord. At page 13, my FIR, my lord.
No, you took time
Yes, my
at
lord.
the time that someone is coming.
My lord, yes. He's coming, my lord.
No, it cannot be wait again. You just start.
My lord.
You want to start it now. কি কৈছে বুঝি পাও না।
My lord. I'm like.
You want again time or what?
No, here 2 p.m., my lord.
I cannot say 2 p.m. because I have some other work.
Lordship, I can start, my lord.
Huh?
Start, my lord.
Oh, you can start. Yes. About perhaps a bye কৈছে।
My lord. At page 13 FIR, my lord.
It's in a motion stage.
Motion, my lord.
13 is the
Yes, my lord. FIR, my lord.
Hmm.
Lecture 1, my lord. May I read, my lord?
yes.
With due to the officer in charge, Dispur Police Station, subject FIR, with due respect, I beg to state that I was staying as a tenant at Sakuntala Port near downtown. Today at about 2:30 p.m., the house owner Ruby Soikia along with goons evicted and ousted me from her house and snatched away my mobile phone and assaulted me and taken away my household articles. Also, I have lost my many articles. Therefore, my humble prayer before your honor, kindly take necessary step against the accused persons. Against him, lordship, plain reading of the FIR, my lord, only allegation against the Ruby Soikia, my lord. He is the landowner, my lord, landlady, and he
With some goons, na?
goons, my lord.
That is there.
We are lordship because
Not only against Ruby Sokat, she
My-
was accompanied with some goons.
my lord, I am praying for staying in complaint case, my lord. Accused number 5 and 6, my lord.
Huh?
Accused number 5 and 6, my lord. He-
Petition number 5 and 6.
6, my lord.
Ah.
They implicated this petitioner, complainant implicated the officer in charge of district police station, my lord.
কি করছে বুঝানো?
And sub-inspector of the district police station. my lord. So she kindly see,
The petitioners are the inspector.
officer in charge of district police station, my lord.
This Biswajit Devnath and
Yes, my lord. And Sabuddin Wadbuya is a sub-inspector of district police station, my lord.
Acha, they are shown as an accused number.
5 and 6 in complaint case, my lord. First, initially, she filed a FIR, my lord, before the officer in charge of district police station, my lord. Thereafter, my lord, lordship, you kindly see, the police immediately taken steps and forwarded this lady to the medical, my lord, to medical checkup, page 19, my lord. In next are 2, my lord. Immediately, they have taken steps, my lord. Thereafter, they visited the spot, my lord, and medical report is lordship, kindly see page 21, my lord, in next are 3, my lord. They are taken up the lady, my lord, to the hospital and all medical examined, my lord. Thereafter, my lord, their statement also recorded, lordship, kindly see page 22, my lord. Recorded by police, my lord, the petitioner, my lord. My name and address are true as mentioned above. I am the housewife and I was a tenant of Ruby Soikia house at house number 20, Sakuntala Road in downtown. The landlady suddenly asked me to leave the house. I told her and that I would need time to find my house. I wanted a few days for that, but this landlady often pressured me to leave her house. But today, 13/5/2023, at about 2:30 p.m., the owner of this house, Ruby Shoikia, brought some strangers, probably bouncer, and threw me out house without the conversation, without informing me, and thrown my furnitures from the house. And when I tried to stop them, Ruby Shoikia and the people with her abused me and treated me and beaten me. They took lot of things from my house and lots of necessities. And then I come to my.
I'm sorry, Malad, I was on legs, Malad. Malad, the issue is, Malad, here is a complaint case. Malad, the state is a formal party. The respondent number 2 filed an FIR. We are the sub-inspector of Dispur police station. At annexure 2, page 19, Malad. Malad, where the complainant filed a, sorry, Malad, it is at page 13, annexure 1. Malad, he files a FIR against against one Ruby Shoikia, page 13. Your Lordship has got it. Ruby Shoikia saying that she is a tenant and she has been forcefully thrown out from the house. So as my duty is this, I send her for medical examination before the authority. And there was a medical examination of the victim. Then, my lord, I took a statement at page 22. My lord, at page 22, a statement of the victim has been given. Then, my lord, I filed a charge sheet at page 24 in that case, my lord. After calling the accused in that case at page 26, my lord, under 41A notice, I requested the accused to come before me, and my lord, after taking her statement, that is at page 29, my lord. Page 29, after taking a statement, I filed a charge sheet that is at page 2024. Page 24. My lord, after this charge sheet has been filed, in that case, as my duty submits, my lord, she files a complaint case, now suppressing all the earlier facts, alleging my name also there at page 33, respondent number 6 and 7. She files a complaint case against as police inspector. 5 and 6. Sub-inspector 5 and 6. That is why I am before your lordship. This is absolutely an abuse of the process of the court. These are just, if this type of tendency is there, my lord, the police will not be able to perform their duty.
Now, what is your allegation against you? What is the allegation brought against you?
My lord, that is at para 7. My lord, now they are placing the complaint painfully state that some of the police officers named as the accused are in collusion with the other accused person doing those illegal acts as such. The complaint did not approach the police station. My lord, I have done my part. I have called the accused. I have taken a statement. I have filed charge sheet. I have done everything. Now, my lord, now because the trial will go, so she thinks that I am also accused. Then how to perform our duty, my lord?
Her thing is to that this section ought to have been registered or charged under section 307, 324,
My lord,
355.
those things can the person instigate filing a complaint case to investigate and file charge sheet in that, or that is the power given to that person, my lord? Now she takes a different role and she files a complaint case against the police officials. And my lord, the charge sheet your lordship will find, my lord, it has been registered under section at page 25, 448, 323, 427, 294, 506 IPC. It has been registered. I have taken statement of and it is a landlord tenancy matter. It's a civil dispute. Just by putting some words cannot be turned into a criminal case. This is only a method approach taken by the complainant respondent number 2, just to harass the police officials for performing their duty. I have taken statement of the victim. I have put her to medical test. I have filed charge sheet. I have called for 41A notice. I have taken the statement of the accused. What more I can do, Malad? Can they say that you should put that section or not? Can anybody interfere? And only because I have not put that, he has put a file a complaint case against me also, alleging taking into account all other persons, Ruby Shoikia, everybody.
The para 8.
Para 8 of the
36. Page number 36.
My lord.
What is this?
The complaint states the accused person in view to criminal trespassing, outraging the modesty, attacking the complainant, kidnapping, outing her daughter Kakuri Bola, her will and likely to compel to marry and force. But these are the statements made, my lord. Can the police officer, then the police officer will never enter anybody's house. What more we can do, my lord? Just putting a statement, my lord, in a complaint case. My lord, then your lordship will find they are the police officers. I have done my part. Just filing a complaint case, putting some statements from the book, my lord. Does it mean there is a case against me, my lord? If that be so, my lord, the police officers will not be able to perform their duty. Is there any laches on my part that I have not registered a case? I have not taken out for medical. I have not asked the accused to come. And my lord, now because she is a defaulter, she is unable to pay the rent. And my lord, her statements are also there that she has not paid her rent, my lord. That is why, my lord, she knows that she is a defaulter. There will be a degree against her. Once a defaulter is always a defaulter, even if it's for a month. Those are the, it starts with non-obstinate per section 5 of the urban area control. But she doesn't want to face the consequence of that suing. She files a case against that forcing me that you will do that or not what I have said. And is it not a abuse of the process? Malad, I will just rely on one judgment, Malad, of 2014-10. Malad, in 10 SCC, page 663, where Malad in page 14-10, Malad in page para 10, page 668, Malad, after discussing all the 482
You are
applications,
going to supply any?
Malad, Malad, your lordship will find in para 2, last Roman 2. Roman 2, Malad, I have last para in that page. Left hand side, Malad, that complainant. If it is an abuse of the process, I have tried to place before your lordship that it is an absolute abuse of the process of the court. Then, Malad, the police officers will never enter, never do their part. How could a police officer do a duty that everybody will put a complaint case against the police officer that you have to put a 307 or you have to do something? Now, Malad, why she has not said that the affair was lost, her statement was taken, she was put to medical college. So those are the suppression of facts in the complaint case. Why she has not said? Why she has lied all this, Malad? And why this complaint case after filing an affair against the landlady? Why this complaint case? It still shows that the malafide intention is there, Malad.
Hard, Mr. PK.
Lordship.
State is a formal party here.
Formal party, Malad, because it's a complaint case.
Hard, Mr. PK Roy Chaudhary, the learned 50 number, counsel for the petition. And also heard Mr. Anand Das. Oh, sorry, KK Das, the learned additional PP appearing on behalf of state respondent number 1. This is an application by Kehin Likhidi, so and so. Issue notice to the respondent number 2 to register area and as usual process. No formal notice is required to be served on state respondent number 1. However, requisite copy may be served during the course of reading. Post next para, considering the submission made by the learned counsel for the petitioner and the annexures file along with the petition, comma, further proceeding in
Complaint case number 21623 pending before the court of page 11.
complaint case number 216.
My lord, 23.
216 of 2023 pending. What is the stage of the case at present?
My lord, appearance.
Evidence. Cognizance already.
Taken, ma'am.
Why have come so lately? At the stage of evidence, why have come?
Not evidence, but appearance.
Oh, appearance. Complaint case 216 of 2023 pending before the court of learned GMFC Kamrup M. We state only in respect of the present two petitions.
5 and 6.
Till next date of listing, list accordingly.
Obligation.
After 4 months. Okay. only in respect of two petitioners.
Wait a minute.
Other issues are also. Orders are there. Admission, how many admissions are there? One,
Admissions are in 4.
1, 2, 3. No, 4? 1, 2, 3, 4.
Or 5. There's one in supplementary hostels.
5 admissions.
Others orders and 1 payment.
I don't know how it can be possible. By 4, I'll rise up.
Yes.
Six, 424. My lord, the background of the case is such that a petition under section 125 was preferred before the trial court for grant of maintenance, my lord.
Yes.
And then there were certain orders of increment of the maintenance after
Enhancement.
division, and it was the order of increment was there. As such, my lord, there's an order dated 2/2019, which is Annexure A, page 18, whereby the maintenance order 4,000 was incremented to rupees 7,000 in favor of the respondent. Now, after this order was passed, 2/2019, the case was kept in abeyance, my lord, because of non-prosecution. 26/9/2019, an order was passed whereby the case was not proceeded with.
No, it was a stay, there was stay order.
Not a stay, my lord, because there was no prosecution from the respondent's side, and she did not appear before the court. It was kept, my lord, in abeyance. In abeyance, my lord, means no order was passed. It was just kept pending.
It was filed. It was filed.
Not 26/9/2019.
Order you have annexed here? Where is the order? 26?
One is Annexure A, page 18, my lord.
The page 18 is a 2/2019 order.
Yes, yes, my lord.
That is the order of enhancement.
Enhancement.
And then where is the order that whereby kept in abeyance means where is it?
7/9/22, my lord. That order is not there, my lord, but it was kept in abeyance 26/9/2019.
26/9.
26/9/2019. Then in the year 7/9/2022,
No, I mean, I could not follow you. Why it was kept in abeyance and what?
because the respondent as the petitioner did not appear before the learned trial court. She did not pursue
Acha,
the case.
acha.
As such, it was kept pending, my lord, but no proceeding, no date was given. It was just kept pending in the court.
Have you annexed that order also?
The statement is there, my lord.
No, order.
Order is not there. my lord.
No,
I don't-
as you have submitted that since 26/9/2019, it was kept in abeyance. Order is there.
It is reflected here, my lord, in the impugned order. Yes.
51.
The impugned
Okay,
order,
acha.
page-
In order itself, it is reflected.
Yes.
Okay,
In the impugned order, it is there.
okay.
So the again she appeared thereafter she appeared on 7/9/2022 and filed a petition for revival of the said proceeding, stating that she was not getting maintenance from the petitioner as such for revival of the same. My lord, thereafter we filed an objection regarding limitation period. And again, she again filed one petition under for condonation of the limitation period. My lord, may turn to page 51 of the impugned order. The factual part is there, my lord. If I may just read it, my lord, will be page 51, my lord. The factual matrix, my lord, second part. Factual matrix of the matter at hand, in a nutshell, is that my learned predecessor, by order dated 2/2019, had enhanced the maintenance amount from 4,000 to 7,000 against the claim of enhanced maintenance of rupees 12,000 per month on the ground of an amicable settlement by the parties. Subsequently, the matter was put up on 28/3/2019. But since then, on the subsequent 6 dates fixed by the court, both the parties remain absent without any steps. And accordingly, my learned predecessor, while order dated 26/9/2019, had temporarily filed, closed the case till appearance of the first party. Ultimately, the first party had appeared on 7/9/22 and filed the instant petition number 451/2022, which was objected by the second party on factual and legal grounds. My lord, the next para is very important, my lord. In her examination in chief itself, the first party admitted that she had gone to Guwahati along with her son to live together with the second party and their daughter. It is also admitted position that the first party had been living with the second party till 14/5/2020, and during that period, the expenses for her maintenance and other expenses were borne by him. And so, she had not made any claim for that period. She also admitted that she has not mentioned anything about the reason of delay for filing the petition till 7/9/2022. She further admitted that she had not filed any complaint before the police and court alleging physical and mental torture upon her by her husband. My lord, this is again in stark contrast to 125 subsection 4, my lord. What has happened, my lord? They have recorded a settlement, my lord, stating that there has been amicable settlement between the parties. If Your Honor may please to just peruse annexure A, my lord. It's in page, my lord, 49. Sorry, my lord, page 18, my lord. My lord, fourth para, my lord. In the course of hearing, the learned counsel of both parties submitted that the parties have arrived into an amicable settlement and they have no objection if an amount 7,000 per month is fixed by enhancing the amount of rupees 3,000 per month. My lord, this is an absolute, my lord, perverse finding, my lord, because the parties were not present. They were not examined. And my lord, just on the submissions of the advocates, it was recorded that 7,000 we have agreed to pay and we'll pay it. My lord, I have given
Now
my
what to do? It has to be, sometimes it happens and it will be before the court also.
Yes, my
Through council, the one party will be
My lord.
represented through council.
yes.
Obviously, if the council, stays before the court that this is the conditions we are agreed by, then court
But I never agreed
pass
to
the
such a
order.
condition. ma'am.
That is your plea now.
I never agreed to such a condition. ma'am.
You are saying at this stage that you are not
lord, we have filed an
exaggerating, but
objections
your
also,
council has already stated there.
My lord, we have already filed an objection to it, whereby I had stated, my lord, my income is only 8,000. How can I give 7,000, my lord? And apart from that, 125 section 4 was not considered, my lord, because the respondent on her own will came and stayed with me and my daughter along with the son. They stayed at Guwahati, and then without any rhyme and reason, they left me again, and now they have again revived the thing, my lord. My lord, absolutely illegal order, my lord. That has to be taken into consideration because it is a accepted position, my lord. If the wife leaves without sufficient cause, and in my case, my lord, it has not been proved also. It has been recorded in the order, my lord, that no police complaint has been registered or nothing has been there alleging violence or mental violence because of which she had to leave the husband. And my lord, section 125(5) is pretty much clear. On proof that any wife in whose favor an order has been made under this section is living in an adultery, or that without sufficient reason she refuses to live with her husband, or that they are living separately by mutual consent, the magistrate shall cancel the order. So she has to prove, my lord, that sufficient cause was there. It was not proved, my lord. And moreover, I am paying my lord. I've been forced to pay, my lord. If I would submit, my lord, 7,000, I'm still paying, my lord. On every day, I'm paying. The case is still going on, my lord. And arrear is also being, my lord, without considering the limitation, they have the Honorable Trial Court has come to a finding that the delay has not been explained, and then they have clapped an area of maintenance upon me, my lord. They've gone ahead and fixed the date, my lord, 2/10/2021. From that date, area maintenance is being, an order has been passed.
Since when? Wait, when?
2/10/21. Without taking into consideration that there has been a settlement where the wife was willing to stay with the husband, and she has in fact stayed with the husband, as has been reflected in the order itself. Now, that being so, the 125 provision of 125(4) has been completely bypassed. And now I'm being pressurized to pay, my lord, 7,000. And now I have an ex, my lord.
So
this
the
is a-
period when she was with you, that period is already, I mean,
that has not been calculated. But the plea which she has taken for the limitation condonation is Corona. ma'am. Corona was effective in the the year of 2020, madam, when she was with me. And this petition was filed in 2022, madam. When Corona was not there, no restrictions were there. So no delay has been explained, madam. It's such a completely perverse and illegal order, and I've been subjected to pay such an amount, madam. I am not saying I will not pay, my lord, but according to my means, I have to pay. This cannot be a milking cow, my lord. The maintenance proceeding cannot be a milking cow, my lord. Out of my capability to pay, that has to be assessed, my lord, and then only from that amount I'll be able to pay. My lord, I have papers are there, my lord, I have filed there. My income is 8,000, my lord, and 7,000 they are burdening me with the 7,000. This is not possible, my lord. We are 4 family members. I and my daughter stay in Guwahati, and my wife and my son stays there, Shivsagar. So I have to take care of my education of my daughter also. That has to be taken into consideration. And my lord, I have annex now. This is my lord, subsequent development. But right now, I'm not earning also. The previous job I do not have. Apart from that also, I am not saying I will not pay, my lord. I will pay, but according to my means, my lord. 7,000 is too much, my lord. And my lord, some for family matter, my lord, some form of amicable settlement.
The fact remains below. 125(4) will come into play when they are my lord husband and wife. Portion will finally come to page paragraph 2, my lord, page 4.
Page 4.
Page 4 of the petition. The marriage was already dissolved on 8/9/2015.
Para 4.
Paragraph 4, last 3 lines. By a decree dated 8/9/2015, the marriage between the parties was dissolved. Paragraph 2, my lord, last 3 lines.
No, from where? Oh, acha, yes, yes. Yes.
It is their petition, my lord. Now, the marriage is dissolved. Now, what has happened, my lord? We have, my lord, 1 daughter and 1 son. The daughter resides with the, my lord, father. The son resides with me. My lord, on 29/10/2009, the maintenance order was passed, my lord, where 3,000 was given to the son, 2,000, my lord, that is paragraph 3. 3,000 was given to the son, my lord, and 2,000 was given to me, my lord. They went on revision. The amount was reduced to 4,000. This was an order of 10/5/2010, my lord, paragraph 4. 3 was the initial maintenance.
Revision, it was reduced.
That is your lordship will find that is page 5. Order dated 29/10/2000. Sorry, my lord. 10/5/2010. It was reduced. Thereafter, my lord, in 2017, I filed an application for enhancement under section 127, which was registered as Miss Case number 2 of 2017, which my learned friend has just referred to, my lord, at page 18. It is not that the council had appeared. Your lordship will that if your lordship kindly comes to paragraph, so page 18, my lord, the order dated 2/2019. In the course of hearing, the learned counsel of both the parties submitted that the parties have arrived at an amicable settlement. It's not the council had consented, my lord. It was on the basis of the instructions given by the parties, my lord, that settlement of the arrear, my lord, that 7,000 was given. It was being paid, my lord. Now, what had happened, my lord, in between, my daughter, my lord, she was to appear in her HSLC bill, matriculation. They reside here. The petitioner approached me, my lord, for taking care, for the purpose of taking care, my lord. I was asked to come to Guwahati. During that period, my lord, a period of 1 year, my lord, I was at Guwahati residing together. Not as husband and wife. We did not have any marital relationship. After the examination, my lord, the same factors again took place, my lord. I was being tortured. Ultimately, I was again compelled to leave the place. Thereafter, my lord, I filed this application. My lord, the period, my lord, initially during the 127 proceeding, my lord, the case was kept filed since there was no appearance. In fact, I was in Guwahati at that point of time. Plus, my lord, the COVID situation there. Thereafter, my lord, after I went back, my lord, I filed an application for reopening the case. Now, where is the, my lord, my lord, unjustified? The order is not unjustified, my lord, because the period, my lord, when I was staying with my husband, that has been exempted, my lord, that has not been included. I am unemployed. I have a son, my lord, from the petitioner. How do I survive? The amount is 7,000. Now, of course, my lord, the area maintenance, my lord, that has been calculated. It will come to around 196, my lord, whatever. There is no illegality in the order, my lord, because the period, if the learned court below had calculated the entire amount during the time of staying together, my lord, that the matter would have been different. 125(4) will come into play, my lord, only when we are married. The marriage has been dissolved long back. Even, my lord, during the COVID period, my lord, the period from 15/3/2020 to 8/28/2020 has been exempted by the Honorable Apex Court. Even otherwise, my lord, when I was not being paid, I approached the court. And the amount has been calculated from the date of the application. Where is the wrong, my lord? But in fact, if your lordship, annexure D, page 28, you know, is the objection, you know. That will, my lord, clarify the case, you know. Page 28.
Yes.
Just paragraph 2, my lord, second paragraph, that the petitioner has paid for enhancement of maintenance amount of rupees 12,000 per month, but the opposite party had agreed to pay rupees 7,000 per month, and the petitioner also agreed with the opposite party, and both the parties have arrived at an amicable settlement. Accordingly, after hearing both the counsels for the parties, the court was pleased to allow maintenance allowance of rupees 7,000 per month by order dated 2/2019. In the meantime, the opposite party came to the residence of the petitioner and cordially requested the petitioner to go with the opposite party and to look after their daughter, who resides with the opposite party, as she was appearing in her HSLC examination 2020. The petitioner, being a mother of the girl child and thinking about her career, went with the opposite party to Guwahati along with her minor son and stayed with the opposite party from 29/2/2019 to 14/5/2020. The opposite party gradually became furious to the petitioner, and even now and every now and then tortured physically and mentally to the petitioner as well as her minor son. That due to the atrocities of the opposite party, the petitioner and her minor son was compelled to return back to her parental home at Sapekete on 14th of April 2019. It ought to be here in 2020. Now, lordship will paragraph 30, sorry, page 30, paragraph 3, second paragraph, Milo. It is stated that the petitioner did not file in withdrawal petition to withdraw the case before the learned court. The case is temporarily filed closed till the appearance of the petitioner by the order dated 26/9/2019. The case was filed, Milo. I filed an application for reopening, Milo. There is no bar as such. Well, how do I survive, Milo? Because, Milo, I have a daughter, I have a daughter with, sorry, Milo, I have a son with me. I claim, my lord, I claim enhancement maintenance at the rate of 12,000. The petitioner himself agreed to pay 7,000. That is way back in 2010. Prices of commodities have increased day by day, my lord. Now, how do I survive with my son? There is no illegality in the order, my lord. In fact, this petition is liable to be rejected, my lord.
My lord, one small point, my lord. My lord, if your lordship may be pleased to produce section 125 CRPC, my lord, their definition of wife is given, my lord. Wife includes a woman who has been divorced by or has obtained a divorce from her husband and has got remarried. My lord, even if divorce is there, my lord, 125(4) has to be applicable, my lord, because they stay together.
That's why she's claiming.
Yes, yes, my lord, but that's why 125(4) has to be applied, my lord. It is not that after divorce, 125(4) does not have any effect. That has to be taken into consideration. And one more thing, my lord, regarding the settlement, my lord. If your lordship turns to page 21, my lord.
21.
21, my lord. This is my objection against the notice issued to me for after they filed their reopening petition. So I filed an objection there, wherein in page 21, I have specifically stated, my lord, regarding the settlement as to what is the settlement, my lord. I have objected to it, my lord. Para 2, my lord, that the petitioner meanwhile preferred the aforesaid petition praying for the enhancement of the maintenance amount. This court passed the order dated 2/2/2019, enhancing the maintenance amount to 7,000 per month, entirely on the ground that the parties had arrived at an amicable settlement. The opposite party states that the observation as regards the amicable settlement between the parties was not in respect of any monetary settlement. Rather, the settlement was in respect of an amicable settlement of the dispute between the parties. However, the counsels representing the parties could not make the submissions as regards the actual state of the matter. In a proper perspective, as the parties, particularly the OP, was not present in the court on the date fixed, and the talk of compromise which was going on between the parties could not be communicated to the learned counsel. So there was no agreement, my lord. In my absence, it was said like 7,000 is being agreed by both the parties. So
That was never challenged, my lord. That order was never challenged, my lord, in the High Court at this stage, my lord.
but that order has culminated in the present impugned order. Such some consideration has to be given. My lord, if and this honorable court fixes the seal of agrees with the order or does not set aside the order, it would amount to going on with the illegality. It's a complete perverse order.
I think, my lord, my learned friend was referring to 125(4), my lord. I'll just read out. No wife shall be entitled to receive allowance or for the maintenance or interim maintenance or expenses as the case may from her husband under section if she is living in adultery. That is the first condition, my lord. Or if without any sufficient reasons to refuses to live with her husband. Now, after divorce, my lord, there's no question of staying together. So, my lord. But otherwise, my lord, I am entitled to maintenance, my lord. That petition is liable to be rejected. My lord. That is my prayer.
But there is a compromise that has to be taken into account. That was there.
The compromise, yes, but to the extent of 7,000.
No, madam. That's completely.
That order was never challenged.
Now, at this stage also you want any compromise. Because 7,000 is already there, apart from 7,000, no other enhancement is there. So you have filed this petition for maintenance after divorce or
No,
prior to? Then is there any order in the divorce, but decree of divorce itself?
No. But here, maintenance order was on 29/10/2009.
Before the divorce.
Before divorce, my lord. The marriage was dissolved on 8/9/2015.
At the time of dissolving the marriage, is there any objection from his corner, his side that maintenance regards to maintenance? Or other orders no is there?
In fact, that is why, my lord, these orders were never filed.
At that point of time, my lord, on the strength of the earlier orders, my lord, it was 3,000 plus 2,000. 3,000 to the son and 2,000 to the wife. As such, there was no question of objection because it was favorable for me, I mean, the amount. In 2019, it has been announced,
Here,
saying that there has been a compromise, but
reduction order in the revision petition was, my lord, on 10/5/2010. I mean, enhancement, my lord, the enhancement petition was, the order was on 2/2019. So, my lord, 19 and this is 24, end of 24, my lord. Can it be challenged, my lord? What cannot be done directly, my lord, cannot be done indirectly.
no, my lord, but that has culminated into the MPN order 6/4/24.
Order is reserved or passed.
22.
May I please, your lordship? 19. And what about 20?
20 after. It was successful.
22.
My lord, the opposite party has filed affidavit in opposition, complaint copy of which is furnished today, my lord. I have to file an affidavit in reply, so matter may be fixed after one day.
The affidavit, I am appearing for respondent number 2, my lord, in this matter. Affidavit in opposition, my lord, is filed on 30th of October, my lord, 2024. But subject to correction, my lord, without the annexure copy, my lord. I have
Yes,
today filed it.
Yes.
Furnished my lord.
Today you have furnished.
Today I have the annexure, only the annexure part I have furnished. my lord.
Only the annexures you filed. And the petition filed early.
Petition earlier, my lord, October, but
Done?
Matter may be fixed
that is
after 1
all,
week.
my lord. Mail petition.
Yes, what to say?
My lord, this matter may be fixed after 1 week.
1 week will not come, it will come after vacation only.
Okay, my lord.
We don't have any day. You want to file and again reply?
Yes,
Verbal submission will do. Anyway,
my lord, actually my senior is on leg in another court.
your Mr.
He will respond.
He will
For respondent number 2, my lord.
correspond number 2. And your Mr.
SI Khan, my lord.
S.I. Khan. Heard Mr. S.I. Khan, the Rani Council for the petition. I also heard Mr. T.U. Taskar for the respondent number 2. It is submitted by Mr. Khan that he has received the copy of affidavit in opposition today itself, and hence needs some more time to file the affidavit in reply or to and to argue the matter. In that context, Mr. Taskar, the learned counsel for the respondent number 2, submitted that the affidavit in reply has already been filed on 13th of October 2024. Only some annexures are being furnished today to the learned counsel for the petitioner. However, considering this submission made by both sides, let the matter be listed immediately after vacation. It will be listed immediately after vacation. By that time, if you want to file any, you can do.
Right.
23.
Yes.
Respondent number two appeared, my lord.
Yeah?
Respondent number two appeared, my lord. He is the complainant of NI case, my lord.
For the respondent number 2. Yes.
I have challenged the order dated 29/5/2024, page 34. The petitioner, my lord, filed a petition under 311 of the CRPC for re-examination of the complainant, my lord. And that one.
Re-examination of.
My lord. And that one was rejected, my lord, by order dated 29/5/2024, my lord. There is a, my lord, page number 34. Then is absent by petitioner so the absent is noted. And relevant portion, my lord, kindly see, my lord, paragraph page 35, paragraph 7, my lord. That is appears that section 311 of the CRPC gives full power upon the court to allow examination of people and examination of witness. But such power must be exercised for judicial decision of a case. In this regard, the Honorable Appeals Court so and so, it is to be remembered that exercise of power 311 of the CRPC should be resorted to only with the object of finding out the truth and obtaining proper proof of such fact which lead to a just and correct decision of the case. It is also settled position of the law that section 311 of the CRPC cannot be allowed to fill up the lacuna of the prosecution case. The record reveals that complainant filed this case against accused under section 138 of the NI Act, and complainant filed this evidence on affidavit. The complainant was cross-examined by learned defense counsel on 22/9/2023. The accused preferred an instant petition at the stage of examination of the accused under section 313 of the CRPC. Paragraph 10. The cross-examination of the complainant shows that already learned defense counsel has thoroughly cross-examined the complainant. The accused has already got the opportunity of cross-examination of the complainant, and after the cross-examination, the accused cannot claim further cross-examination on the ground that the learned counsel missed some question due to inadvertent mistake. It appears that accused has filed the instant petition to fill up their lacuna, which occurred during cross-examination of the complainant, and as already stated above, section 311 of the CRPC cannot be applied for filling up the lacuna. Further, after going through the petition, it appears that accused has actually sought for further cross-examination of the complainant, but section 311 of the CRPC does not provide for further cross-examination of any witness without recording further examinations. Hence, considering all the above, petition number so and so is rejected, accordingly disposed of.
Now, why you filed the petition? What was the reason? What
reason? What
some ground?
questions on the some checking question, some questions asked to left out to ask some.
To whom you want to cross-examine?
The complainant. That one rejected.
Have you furnished any questionnaires to that these will be the questions? The relevant questions?
I have not specifically stated in the petition, my lord, page 29, my lord. Page 29, that petition, my lord. That on 22/9/2023, although the complainant had already been examined in connection with the above noted case, but some of the material questions which are inadvertently dropped to ask the complainant at the time of his cross-examination regarding check in question and relating to other material fact of the complaint petition, also for proper adjudication. Now the matter is fixed on 12/12, my lord. for DW, my lord. After issuing a notice, my lord, I filed a petition at the stay of the proceeding, my lord, but that one also rejected, my lord. One opportunity, my lord, must be given, my lord, to, my lord, examine the accused, my lord.
Yes.
So for that reason, concern case 29, in that regard, I have multiplied in case 31.
31.
31. The decline para 4.
Category specifically stated, para 4 of page 31, that the complaint was duly cross-examined by the learned counsel of the accused petition and so and so, consisting 5 pages, five number of pages at a length, and the evidence for the complaint side was close so and so. Lordship, the accused before your honor, he's an advocate by profession, and he is a special prosecutor in POSCO court, Lordship. He has a well-advanced knowledge regarding the proceeding of the case, and only the process is the procedure to make the case detailed. That is the issue to my simple prayer. And so far, he is well about the process, how to file the petition under 330, 311. And when he filed a petition, at the same time, the probable question should be enclosed there, which was not done. And accordingly, order was passed rightly. And my humble appearance as regard to the accused, if honorable court allow the petition, I have nothing to say. But thing is that they should file the probable question. Therefore, because that is the law. That is the law I'm saying. No. So only the thing is that I'm entitled to get 3 lakhs, Lordship. Only they're making my payment delay, Lordship. This is my humble prayer. Nothing to say. And order specifically stated in para 34 in para 10, that page 35 para 10, cross-examination of the complaint was shown that already learned counsel has thoroughly examined, thoroughly cross-examined. This is the order. Nothing is left. Nothing is left. Only the purpose is to fill up the lacuna. So my priority court has directly passed the order. Thoroughly cross-examining. Now up to you, Lordship.
Sure. No, listen. I did some judgment in those 2 matters. First can be important. Yes, the previous is here also. Hard Mr. Yapatgil, and Mr. K.R. Patgil, then counsel for the petition, also hard Mr. Dilip Dilanet, counsel for the respondent number 2, and MS and Mr. K.K. Das Dilanet, additional PP for the state respondent number 1. You are just formal party here. This is an application filed by the petitioner under section 528 BNSS, challenging the impugn order dated 29/5/2024, filed by learned additional CGM Borpeta in connection with NI case number 13 of 2021, rejecting the petition filed under section 311 CRPC by the petitioner. Poster. It is submitted by Mr. Patkari that after completion of the prosecution witnesses, the case, we have filed the petition at this stage of 313.
My lord.
At this stage of 313.
My lord.
After completion of the petition, after completion of the PWs, and the case was fixed for this recording of 313 statement of the present accused petitioner, but these days of 313, na? The petition, no, last line to box. 13, when it has come into the knowledge of the petitioner that inadvertently some of the valid questions were not put to the PW1, the complainant, who is the one of the vital witness of the case, and case at the time of cross-examination regarding the check-in question. And some other material facts were also not brought into while cross-examining the PW1. Accordingly, the petition was filed as the further cross-examination of the PW1 is required for proper adjudication of the matter. But the learned trial court below had rejected the prayer by order dated 29/5/2024. 24 with the observation that the PW1 was cross-examined in detail and the petition was filed only to fill up the lacuna. On being agreed with the said order passed by the learned trial court below, the present petition has been filed for setting aside and quashing of the order dated 29/5/2024, allowing the petitioner one more chance to recall the PW1 and to cross-examine him on some very vital points which were inadvertently omitted by the learned and his counsel at the time of cross-examining the PW1. Next para. Mr. D, the learned counsel for the respondent number 2 submitted in this regard that he is the profession by advocate by profession. The petitioner.
Yes, yes. Page 4, they have explained. Page 4, first paragraph. The accused petitioner is a special public prosecutor in the learned court of session judge Borpeta. Specially deals with POSCO cases. Therefore, is their petition.
Oh, who is a special public prosecutor?
Yes.
What is his name? Ranjit
Name?
Kumar Deka.
Ranjit Kumar.
Submitted that the accused petitioner, being the practicing advocate and who is presently discharging, who is presently working as a special public prosecutor in the court of Borpeta, had every knowledge and experience to cross-examine, how to cross-examine the witnesses, and that apart, while filing the petition for recalling the witnesses, no, the questionnaires were not brought before, not brought in the petition, on which the PW1 was to be cross-examined. Further, he submitted that the PW1 was cross-examined in detail. Five numbers of pages from where? I mean, including the chief also? Only cross?
Cross-examination of the complaint shows that already learned defense counsel has thoroughly cross-examined the complainants. That is in order sheet, page 35, para 10. Cross-examination of the complainant shows that already learned defense counsel has thoroughly cross-examined the complainant. The accused has got the opportunity to cross-examine the complainant.
No, okay, it is observation of the court. Your observation is 5-page length, ne?
Yes, that is my objection.
Acha.
Court has in para 10, thoroughly cross-examined.
It is happening. Detail and 5 numbers of pages were at length. No, in detail. And And after detailed examination of the PW1 and other witnesses, the prosecution witness evidence was closed. Full stop. He further submitted that the court, the court cannot exercise the power under section 311 CRPC only to fill up the lacuna, and it can only be and the order of under and can be only allowed when it is essential for the just decision of this case. Accordingly, he raised objection and submitted that this is not at all a fit case wherein the prayer for recalling of PW1 can be allowed at this stage. First of if DW is there, no? It is fixed for DW. He further submitted that submitted that the learned trial court below had passed a detailed order and detailed order with the observation that the petition under filed under section 311 CRPC cannot be allowed only to fill up the lacuna and it also cannot be allowed to fill up the lacuna, and also observe that the petitioner got ample opportunity to cross-examine the PW1 and from the examination sheet also it is seen that there is the PW1 was cross-examined at a length, and accordingly with those observation and with the in view of the decision of the Honorable Apex Court, the learned trial court below had rightly rejected the prayer of the petitioner filed under section 311 CRPC. After hearing the submission made by the learned counsel for both sides, it is seen that the petition was filed at a stage of recording of cheat written statement of the accused petitioners and after closure of evidence of the PW1. It also cannot be denied that the PW1 was cross-examined at a length and the cross-examined at a length, full stop. Further, it is seen that for the length, that's a back in Twitter, what are observations? These are 313, 311 or observation to again. I'll pass the remaining portion because I have some what to say, your decision. I will have to incorporate it. Your petition otherwise will be allowed. Disposal.
25.
The disposal of this. 20. How was any?
My lord, may I please, your lordship? My lord, my vehicle was, lordship seized on 28/2024. lordship.
The report
Now-
is received. Huh? When your vehicle is seized
My
on
lord, on 28/2024. lordship. So. now-
28.
uh,
Oh, no, no.
28/3, lordship.
28/3.
Yes, lord. Now more than 8 months already passed, lordship. So.
What is your
I
say?
have
Why
deprived, lordship.
report is not there?
Maybe.
But it was,
My lord,
the last order was passed on 26/11. Obviously, and not take instructions otherwise. Tuesday may not be possible. Wednesday also, I don't know. He will better. What to say? Nothing to say. If it is possible, then after vacation only, because prior vacation.
My lord, I have a.
What
my
to
lord,
say, you are there,
I
but
have
we
been
also have
deprived
to see
for
the time.
enjoying
We
my
don't have other
vehicle,
opportunity.
lordship. My lord, before vacation ending, my lord.
Before
kindly.
vacation, we don't have any days. Main problem is that.
My lord, because my lord, this is a small.
No,
thing,
whatever,
lordship.
small, I have to hear, we have to pass the order. You know, after the court hours, I used to stay here till 7:30 to 8 only. Then only I left the court premises. But it's not
I am
easy to
sorry.
say that the order is there. It's not there. I used to stay till 7:38.
Then on 6th of January or 7th of January, my lord. Date can be fixed, lord.
Court khula ase na bond?
30 is open.
Third is open.
Then
If you
six-
can take instruction within this period, let it be on 3rd only, 3rd of January. Will do.
Third perhaps not possible for me, lordship. On 6th, my lord.
4th and 5th is holiday.
Yes, lordship. So 6th is
Sixth, okay.
Monday, lordship. So 6th, lordship.
You take, bring the report, but he rightly submitted that it is about to be 8 or 9 months. The vehicle is in there. So what purpose they are keeping the vehicle? At least you bring the report. Otherwise,
deteriorating,
vehicle,
lordship.
our case is relates to what kind of case?
Lordship, that my son, lordship, that allegation is that my son used the vehicle, lordship, for some offense, lordship. For which
What kind of offense?
that offense is, lordship, 302 120B, that section.
302 was there.
Yes, lordship. But lordship, vehicle is not involved, lordship.
So your son is otherwise charge sheeted.
Not charge sheet was submitted, lordship. My son
But
was
you are
arrested, subsequently
arrested.
he was released on bail, lordship.
You are not entangled with
No,
that
lordship,
case.
I was not in.
Arts and so report not received. The learned additional PP is hereby directed to produce a report on or before next date. And the Mr. Das is also hereby requested to make personal communication with the concerned IO so that report can be reached on or before the next date of listing. List accordingly on 3rd. Oh, sorry, I mean 6th.
Obliged, lordship.
43 and 44 of the supplementary list. It's a-
14. Yes, it's good. Come on.
After sometimes, my lord. As because my lord.
I'm rising a bit early today by 4 because I have some personal issues.
Because,
We are keeping it. Let us see. Oh.
yes.
For orders, item 28.
The services not complete as per office of lordship. Lordship kindly allowed for proper publication, lordship, in one proper publication, local paper publication.
Paper publication.
Yes, lordship. 2 times I will take steps, lordship.
Criminal, yes, does. Paper publication will serve the purpose here or what to say? Oh, you are not the party, I think. Na? It's a criminal revision.
Yes, lordship. In as well.
Why your address is not proper?
Yes, lordship. I have taken steps, 2 times taken steps. His office also, his service also.
Where is the report? Office note?
2
19.5.
times I also taken steps, lordship. His home address, I also taken steps, and his official address also I have taken steps.
No, your address is proper.
Proper, lordship. He is central government employee, lordship.
Central government employee.
Yes, lordship.
So this is your official address or personal address?
Personal address, 2 times taken steps. First time I'm taking steps in home, lordship, residential address. And second time I also official address. But both are, lordship is not completed. So I last can be given to a paper publication.
Problem is that the service is, I mean, we are not receiving the answer notice also.
Yes, lordship.
Why? He's a central government employee. How many limitation was 484 days?
480. His parents, I am informed, Lordship, his parents. also
He's from Dhemaji.
Yes, Lordship.
This, the address you have given here, it is his residential address.
Yes, Lordship.
And official address also, you know.
Oh.
Do one thing. First of all, as the registered AD is not yet received, issue notice through the jurisdictional police station if it is permanent, address is permanent, before going a step ahead
Okay, Lord.
for proper publication, because paper publication may not serve the purpose also. So do it after in both the addresses through jurisdictional police station. His present address of posting is where he is now posted presently.
I have not taken instruction.
You take instruction because only one address is here. That is his personal address, residential address. And take steps in both the addresses. As you have stated that he is an very employee. Okay.
Concerned police station, Lordship.
Is obviously you are Mr.
And
N.
Borwa, Lordship.
N. Borwa. Hard Mr. N. Borwa, Development Council for Deputy. I had to লিখে দিব. So and so. Office note dated 29/10/2024 reveals that the service is not yet completed on the sole respondent. Just respondent, neither the foodstuff, neither the ID card nor the answer notice is received back by the office. Mr. Borwa submitted in his record that he already took steps on 2-3 occasions, both in official address as well as in his residential address. Post of we further submitted that the respondent is a central government employee full stop. Considering this submission made by the Learned Counsel for the petitioner, let a fresh notice be issued through jurisdictional police station in both the addresses, that is in official address as well as in the residential address of the respondent. Take steps, petitioner will take steps within 1 week. Will hear. You take steps this time. We'll see. List accordingly after 4 weeks.
Date may be kindly fixed.
Date cannot be fixed. Let it come. 4 weeks.
31.
Okay.
Maybe. So when a notice was issued and we have taken steps twice, but the service not complete. So my prayer, amicus curiae may be appointed.
It is some kind of report. What is the report? The answer report is there or answer? Address is proper.
That is proper. In the result, they are given same as we have mentioned here.
Otherwise, it's a POXO. It's not a key question.
So under section 6, he has been convicted for 10 years.
He received 2/8/2020.
So legal counsel or amicus curiae may be appointed so that it can be disposed of early.
Steps was taken under which manner? Dates it key লিখেছে 2/12/2024 লিখে দিই 2/12/2024 আহাই নাই দেখা ও আহি গল না কি লিখেছে নাই আহানি ঘুরি steps to register post was taken on main case and not interrogated ও এটা লোৱাই নাই মেইন কেস তো হবই নোৱাৰে এইটো হেৰি হয় নেকি এইটো আপোনাৰ section 5 limitation oh no releasing main case of লৈছে নেকি step তাত কি বুলি আছে আহাই নাই awaited you have not taken steps in the this case you have not taken steps huh but office note says office note speaks that you have not taken steps for in I The report will come
I criminal number 292/24.
it is from
It is by the official, after
just tell us under which process you are taking steps in fact
this now, a rule is there, we have to
Deepak
start
Nayak,
reporting to the
yes.
government, PP, and PP will sub them, through the
PP can you tell us whether
And it's some time.
because it's not main case should
Now I have not received anything like.
I'm sorry,
তাতে through it কিবা হে লিখিছে লৈছে নেকি PP অফিচাৰ ৰিসিভ কৰিছে
Issued on 13/5, we should release the report on 13/5, where the service report is divided.
no through
Registry.
PP অফিচাৰ পাইছে PP নাই পোৱা
Was sent by the registry. Official office and places in the same section.
your office has not received
No, Lordship. No, this is the Kumila we have sub, this is the, they are serial singers, sir.
office
Yes.
of
by
PP
PP.
But
This is the-
for
what is
we
the
have not
similar?
received.
Please find her a copy of the IA criminal number 292/24 in criminal appeal number so for.
it was served on the PP
This is the now.
Registry, so send it to PP office and we send it to OC Lordship. And from that report came up.
you're not I mean directly you serve the notice
No,
or
directly.
from the registry
No, now we cannot serve.
no directly you have to have served this notice
Directly to the PP.
why it has to come to registry only
No, PP will go first, then PP.
registry will send us to PP so that PP can forward it to judicial police station and rest of the inquiry can be done by the
That is the process, Lordship.
I'll take.
but if already PP has received the notice then it's okay otherwise we
Now,
don't
this
have
is the, my, their seal and signature on the
If
no
they have
proof.
taken it, they-
Yellow to make a list.
Not through the PP, because that's why there is a confusion, that's why the office note process. Acceptance notice has.
PP, but one notice is directly to PP offices is sent. It's
Okay.
also here.
Lordship. Then I.
You can make an inquiry otherwise.
I have to make it inquiry. then.
He will make an inquiry.
Well,
Okay. If it is already received by the office of the PP, then he will inquire whether it is, what is the status of the service. Okay.
well. I. Two times.
But Mr. দুইটা কেসতে অর্ডার করে দিব এপিল টু আছে এপিলও আছে আইও আছে দুইটাতে একে অর্ডার করে দিব হার্ড মিস্টার রশিদ সোয়েনসো also heard Mr. KK Das, the learned additional PP, so and so. Office note dated 2/12/2024 reflects that the notice is not issued in the present I, though the notice has already been issued to the respond number 2 in the main appeal. From the record, it is also seen that the copy of the notice is directly served on the office of the PP and not through the registry. However, Mr. Das, the learned additional PP, is hereby requested to make an inquiry in regards to service of notice on respond number 2 or the status of service of only respond number 2. List the matter accordingly on after vacation, and date is not required after vacation, immediately after vacation.
6 or 7 January.
Okay, 6th of January. দুইটাতে একে অর্ডার সাকোচ হচ্ছে দুইটাতে সার্ভিস নোটিস নাই আহা বুলি কৈ পেলাই উইল এনকোয়ারি ম্যাটার বুলি কৈ থলে দুইটাতে সেম অর্ডার করে
P2. Here we saw LCR services.
service and LCR. LCR is not received.
Yes.
Here also service and LCR is both awaited.
We have taken step on 26/11, Your Lordship.
26/11.
Yes, Your Lordship. Pro OC we have taken.
Huh?
Pro OC. The notice was issued on 26/11. The
It is
supplementary
represented
office notice there.
Okay.
Directly to the OC.
কি হৈ আছে আৰু কবি
Notice was sent on 2.
It says that notice was sent on only 2/12, in fact, through registry to OC,
Yes, Your Lordship.
not through PP, I think. It's not there.
The last order was that to throw OC actually.
True?
OC.
No, OC is there. You have submitted
Yes, Your Lordship.
it to direct, registry had directly sent to OC,
Yes, sir.
not through office of the PP.
No.
Anyway, it is sent only on 2/12, so maybe have it.
Service elevated actually.
A
Here,
service can
Your
be
Lordship,
awaited.
half of the sentence he has already undergone, Your Lordship. 2
That
years
has to be
almost.
said what to do.
So before vacation, kindly, Your Lordship.
Before vacation?
Yes, Your
Oh
Lordship.
my God. Not at all possible. Not at all possible. Hard Mr. So কৰি দিব. Service is still awaited for respondent number. It reveals that the service notice is sent to the concerned police station by registry only on 2/12/2024, and accordingly let the service be awaited till next date of listing. Also issue reminder to call for the earlier it was not called for or what? No order is called for calling for the oh yes, call for the record. LCR not yet received, issue reminder. The petition, the registry will do the needful accordingly. List immediately after vacation. Data service. 6 1 4 is a holiday. 6th.
33. Services.
Services awaited for respond number 2. Services awaited for respond number 2.
And for the petition. Step on respondent number 2 was taken by registered post, but as per office note, no AD has been returned. Further, the proceeding in the lower court is not yet stayed. Therefore, it may be fixed for admission hearing at the so that, and in the lower court also dates are given.
No, it can be admission hearing or at the motion stage also matter may be heard. It doesn't, it's not, no, there's no any bar. But the question is, we don't have any service report. That is the issue. Even if it is fixed on
office note, it is awaited.
It's awaited. Scan copy of the record is received already? Is received, I think.
Yes, sir.
Scan copy we have received already. It's here with us. But service is still awaited. That is the issue. In fact, you have from the office note, it also seen that you have taken a fresh notice also.
No.
Steps.
Not.
On 4/11.
No.
4/11. But it's not returned till now.
No.
I wait till next date only. Let us see. On the if it returns or if anything can be done, otherwise in their absence is a criminal petition completely cannot be passed.
It is fixed on 17th.
17 January. Prior to that, you want any day?
Lot.
Okay, we are fixing it on 6th of January. Hard code, Mr. Das presence to DTB. As per office note dated 3/12/2024, the service is still awaited for respondent number 2. Service next, service be awaited till next date of listing. List accordingly on 6/1/2024. Okay, well listed. Sorry, 6/1/25.
Please, Lordship. So in this case, record has already received, Lordship.
Record received.
Received. We have filed this IA for Lordship, allowing her to go on bail, Lordship, during the pendency of this appeal. Lordship, here, he is convicted under section 376 and sentenced for 10 years jail, Lordship, imprisonment.
Now, as it is 376 or POXO, we need the presence of, no, not
Lordship,
POXO, POXO 376, all we need actually the respondent.
Lordship, there is no ingredients of 376 in this case, Lordship.
That is your say, but we conviction is of under 376 only.
376,
Then
Lordship.
what to say? What to
They were in relationship, Lordship.
No, these are all right, okay, but the question is there as this 376 conviction is under 376. That's what I'm saying. Now.
Only for
Notices,
IA, Lordship, may be considered, otherwise the.
Yes. You have filed your objection and what the term of conviction was?
10 years, Lordship.
10 years. File your objection and
Not filed yet, Lord.
LCR, we have received the LCR. If you want to file, you can file. Objection is not received. Already there only note.
Lordship.
Service, I don't know what to do.
After
Lordship, IA will be, if possible, Lordship, IA may be considered today.
No, but 10 years conviction 376. How can you pass the order? Let the PP to submit any, if any objection or verbal submission will also do. I mean, I'm not on that.
Yes.
They can
Record is
peruse the
there,
record and verbal submission, but not today because we don't have any service report on respondent number 2. In fact, it's a case of 376. That's why I'm asking. However, even in spite of amicus can be appointed otherwise. But your last when you have taken steps on 110. You have taken steps only once, no?
Once, Lordship. So otherwise, we have come to know that they have received the notice, Lordship. Informally, we have received the instruction, Lordship. But on record, there is.
No, these are from your side submission.
Lordship,
How can you take all this in account? Otherwise, we have to appoint an amicus.
Lordship.
LCR, we have received the LCR matter, may be finally heard in fact.
Finally heard, Lordship.
We need to file written objection. Lord.
You
Lordship,
filed
on the
it.
last occasion also, they were granted time, they have not filed
I'm
it.
not there at that time, Lord. At that time, I'm not there.
There is no ingredients of 376. There was a consensual relation between the parties, Lordship. And after marriage, on the pressure of her husband, she has filed this.
Maybe.
Lordship.
Your correction submission may be correct.
Lordship.
Hard MS R. David Dillon Council. I'm sorry.
Short date may be given.
Hard MS R. David Dillon Council for the petition, appellants. And also heard Mr. Keketa Zilanet additional PP appearing on behalf of state respondent number 1. Service is still awaited for the respondent number 2. In that context, MSRDB submitted that amicus may be appointed to represent the respondent number 2 as the petitioner is still behind the bar. Mr. Das also submitted in this regard that the state may be maybe 2 weeks. 2 weeks time may be given for to file their written objection. The answer has already been received, so matter may be finally heard and decided. However, the registry is here directed to appoint an amicus to represent the respondent number 2. List the matter accordingly immediately after vacation. It will be listed after vacation. Prior vacation, we don't have any dates.
That can be fixed, Lordship.
Date we cannot fix in each and every case. How can we fix it?
Since he is in jail, Lordship. Since July he is in jail, Lordship.
Sometimes someone too is
Lordship.
in jail for
No,
more than
first
2
week-
years and 3 years also.
January, Lordship.
First week of January, yes. This
Last
stuff.
week.
First week of January.
Date meeting. Obliged, Lordship.
Okay. 45. None appears on call for the petitioner. List after petition.
36.
May I please, your lordship? My lord, I have filed this IA for granting the leave to prepare an appeal against the order of acquittal passed by the learned CJM, my lord. I am the complainant, my lord. I have filed a case under section 138 of the NIA, lord. For the dishonor of 3 checks, my lord. And after trial, my lord, after recording the evidence, the learned court came to a finding that it is my duty to prove that the check was issued in discharge of the liability. That is not the law. You also know that under section 139, the burden lie on the accused to prove that the check was not issued in discharge of the liability, my lord. So on that ground, my lord, I am coming before this.
It was acquitted.
Yes, accused was acquitted. I am the complainant. So I am seeking leave, my lord.
Yes.
File that.
We have to issue notice.
Yes, my
Otherwise,
lord. That is the law.
Filed Mr. R.C. Setty, the land counsel for the petitioner. Full stop. This is an application under section 419(3), bracket 3 of the BNSS, seeking leave to file an appeal against the impugned order. The impugned judgment and order dated 22/07/2024. Passed in complaint case number 2611C 2014, and whereby the learned CGM Kamrup M has acquitted the accused respondents. Issue notice to the respondent through registered AD and as usual process. Petitioner will take steps immediately within 7 days. List accordingly. After vacation, it will be
Yes, madam.
you take steps within
Yes,
2 days. List after.
37.
It is preferred by the state of Assam, Lordship. Whereby, Lordship, there is an IA, criminal number 1202, Lordship.
For leave, seeking leave. আগত যেটো order হৈছে আগৰ যেটো order হৈছে same order হ'ব you drink drinks on these things from here. This is by state. Card MS/SH Bora, they done an additional PP appearing on behalf of the petitioner. This is an application বাকি খিনিকে থাকিব. Issue notice will list accordingly after application.
Organized.
$38.
Last order may be police level.
Last order,
This honorable court, your lordship.
2811.
Yes, lordship.
Yes.
Scan copies of the case records as well as the case diary was called for. It is a Jimma petition, your lordship. Petitioner is neither an accused nor charged, your lordship. His driver, your lordship, is accused and trial is going on against. Since it is POCSO, your lordship, so notice has to be given, your lordship. Accordingly, notice I have taken steps. And I also prayed for.
Now, this is criminal petition for what? Quashing against
Jimma.
case.
No, lordship, for Jimma
Jimma.
of the vehicle that has been used for the offending, for the alleged offense, your lordship. An auto rickshaw, your lordship. I am the owner of that auto rickshaw. I am not the accused, your lordship.
driver of the auto here, charge trial is going on against the driver of the accused. Your Lordship.
So
Yes,
you,
because
you're seeking Jima only.
Zimma only, as because POXO is there, I have made party and notice has been sent to Your Lordship. I have already taken steps, Your Lordship. So far as Dusty, I prayed for Dusty also. But
It was permitted.
yes, Lordship, but problem is that, Your Lordship, there is mega road blockade both in the railway and by motorable through Boragili, Your Lordship. That is why I could not take Dusty upon the respondent number 2. So far, Lordship, may I pray, Your Lordship, amicus for respondent number 2 maybe, Lordship.
At this process, you, some way you complete the process.
Yeah.
Scan copy was also called for.
Yes, Lordship.
Not received.
So take fresh steps for concern of restriction with the workflow of it. And in the
Here, one note is there in the office note, 412. Notice have been issued to the respondent number 2 by registered post with AD and through the district magistrate, Hailakandi, on 2/12/2024. But your order was passed on 28/11/2024.
Yes.
Whereby service was allowed through Dusty also, and
Yes.
but you have taken steps through
Through-
registered post
I
and
made
through
it
district
clear.
magistrate.
Yes.
So better to await the service. It is only on 4/12. Earlier you have taken steps on 2/12. So we can await the service. And by that time, we can issue note reminder, I think.
Yes, Lordship.
You are Mr. Chaudhary?
Yes, Lordship.
Heard Mr. R.A. Chaudhary, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. From the office note dated 4/12/2024, it is seen that service is still awaited for the respondent number 2. Full stop, and the scan copy of the LCI is also not been received. Issue reminder. Registry will take will take necessary steps. And service be awaited for the respondent number 2 till next date of listing. List accordingly immediately after vacation.
After any date, Lordship, after.
Date we cannot fix. After, immediately after vacation.
48 of the supplementary list.
Maybe just this criminal petition has been challenging the impute charge sheet and the cognizance.
No, we're not going to hear the matter.
No, Lordship, but the thing is that the
48 and
48. The LCI has been last occasion. The LCI has been called for, and notice has been issued in the LCI and the service report upon the respondent number 2 is awaited. The thing is that the trial court has fixed the matter on 11. I for a prayer for interim because the prima facie there is no material.
no, the first date interim was not there. We cannot in a position to.
But if you are looking kindly, if you go to the merit of the case, there is 379 upon the employee of a finance company.
No, we are not going to hear the matter. No. So respondent number 2 is.
LCI has already been called for. That has also been not in review before this honorable court today.
Yes, Samyani.
LCI not received. Office dated 5/8/2024.
Through AD and through district magistrate, Tinsukia.
Lordships. Till date, no LCI has been received. But the problem is that the lower court has fixed the matter on 11. For appearance, Your Honor.
Are you any on bail or any?
No, there is no. There is for the second date. I'm not in. I'm already interim bill. I'm on interim. If you also kindly.
Anticipatory was there.
Yes, and already
Then
been
you
absolute.
can appear and file a petition. Your
But
bail.
thing is that there is an abuse process with the court. Now, if you also kindly go to the merit of the case, it is totally abuse process with the court for which.
Okay then.
Lordships.
Heard Mr. M. Purva, the learned H. Purva, the learned counsel for the petition. Also heard Mr. D.P. Goswami, the learned additional PP from the office note dated 5/12/2024. It is seen that both the LCR and the Says the 70 days, the service is still awaited for the respondent number 2, and NCL has also not been received. Issue reminder, the registry will take necessary steps in this regard. And service will be awaited because it is on 5 to, you have taken steps when? You just say
Yes, Lordship, recently on,
2/11,
yes, Lordship.
then it can be awaited at least till next date of
Lordship.
listing. You want any fixed date here?
Lordship.
What a fixed date for you? 22nd of January.
Before-
22nd of January will do? Before
Before, আৰু এবাৰ নাহিব নেকি বাইদেউ? যদি পাৰে,
6, 7, 8, 9 কিবা আছে নেকি চাওঁ। 10th of January.
Lordship, Lordship, Lordship. Leave, leave.
Time being 43 and 44.
It will ask for you already.
43 and 44, my lord, other side is
43.
and 44, my lord, matrimonial matter. Here in this case, the petitioner before lordship, my lord, that's been the lady Rinki Deka.
Who is the other side?
Other side counsel's name has been reflected in the cause list, my lord.
You are for the petitioner or respondent?
There are two, my lord.
Oh, one you're for Harry.
One family court enhance the maintenance of my girl child from 5 to 13, whereas I was praying for 25. The other side being aggrieved, they came to the High Court, and I for enhancement. There are two revision applications against that same.
One is for enhancement.
One enhancement, and another is for setting aside the 13,000 by.
No, but yes, so you are for the respondent, in fact.
One is respondent, one for the petition.
One is for respondent, one is for petitioner.
Number 43, I am for the respondent, and 42, I am for 44, I am for the petitioner.
Then where is who is he?
Actually, Jiaul Kamar used to appear in this case, but his name has not been reflected. So what I'm on at this hour, when the court is whole day, it's been like that way. May I pray? Because this girl's child is good in her studies. She's been studying in Delhi Public School, Delhi Public School. And class, that time when the petition was preferred, she was in class 11 standard, 12. Now she has passed out with good marks and she wants to study in Bangalore for higher studies. Now the husband has been getting a salary railway employee of 1,80,000. And that particular with regard to the marriage between the husband and wife has been dissolved, and thereafter alimony has also been paid. But so far maintenance with regard to the child, 50% with regard to the education expenses and all would be bear by the mother and 50% by the father. That was the interim order earlier and disposed of. Now, as because the child has been growing, expenses are growing, and she being a practicing lawyer, my lord. And so we prayed for under 127 for enhancement to 25. Learned trial court took everything on record and thereafter enhanced to 13,000. And they are not willing to pay 13,000, whereas I am asking for more than 13,000.
So they have come against the 13,000.
Yes, 13,000.
In 43.
Yes, 43. Yes.
And in 44, you are for?
For enhancement of 13,000 to any amount which is reasonable, my lord.
Oh, so
what to do, madam? May I pray for a 13th on this month, if it is possible, because the girl child has been going out there for higher studies, my lord.
Have you otherwise whether there is any talk of between man? I mean,
No, cannot be because he again got married. He have again had children.
No, not on that. I mean, regarding the monetary.
No, my lord, no. Effort has been made in the family court. It cannot be sorted out that way, that manner. That's why last resort is before.
13 to I cannot say at this stage because
only because the girl child wants
from
to
every I mean,
I understand.
Advocates, the prayer is for purification. We don't have any actually dates.
Absolutely, I
The
understand.
19 and 20 we are not giving any dates because all motions matters will be there.
Yes.
And that apart, I have some other personal problems that my private secretaries are from Arunachal. Myself also from Arunachal. So
I understand the difficulty, my lord.
That is
my friend has become now judge. I can see like sitting till 5:30, my lord. And in Arunachal now he's been sitting in Nagaland, Kohima bench. And like it's a service to the nation, my lord, nothing else.
Obviously,
It's a service to the nation, my lord.
He is seeking 13 to 12 পাৰিব নেকি? নোৱাৰে।
নহব।
He said নহব।
কেতিয়া মানে পাৰিব বাইদেউ?
Immediately after vacation.
If you want any date, she is saying that immediately after vacation, so it may on গৈ থাকিব পাৰে। So let it be on 9th or 10th of January, then it can be.
Right.
Or at best 6-7 খোলা আছে নেকি? 6টা মতলি matters আছে।
Because bail matters.
Bail matters are there also. 10th can be.
10th of
And it is
January.
in admission column, we may dispose of the matter in the admission column.
Admission column, my lord. They play
10th of
price for and let Jiaul Kamar name may be reflected, otherwise that can be an excuse, my lord. Because Jiaul Kamar on the last occasion also took time with regard to this, my lord. The senior counsel, Mr. J.
No,
Kamar.
yes, but ইয়াৰ ওপৰত লিখিছে নেকি জিয়াল কামাৰ?
আছে তেখেতৰ ওকলতনামা, my lord. Order sheet ত reflect দেখিব J. Kamar.
জেড কামাৰ মিনিছ দিয়া ন?
Order sheet, can you see the order
নাই।
sheets? আছে ক'বাত?
Yes. In I, no, দুটা আছে একেবাৰে।
IO has been disposed of, Nilo. J. Kamar was there.
Where it's written, it's disposed of.
Order which is disposed of.
Yes, which has been disposed of.
J. Kamar appeared?
Senior counsel.
J. Kamar, yes.
No, that is told already disposed of. Here, after that, whether he appeared. নাই দেখোন ফটো না, দেখা নাই দে।
কিবাটো লাগে
জেড
বাইদেউ।
কামাৰ। No, here order sheets of poor reflection আছে নেকি? Yes, you can check it. Otherwise, we'll ask the registry to put, reflect his name in the cause list, in fact.
It will be reflected because it took time, man. We both together came in and
RM does. RM does.
Yes, yes.
Rajat Kamar is also there.
Okay.
RM Das name has been reflected. in the
Okay, then
contract.
তেতিয়া কৰি দিয়ক আপুনি। বাকী কৰক, Hard Mr. A.K. Bhuiyan, the Learned Council, দুইটা একেলগে লিখি দিব for the respondent oblique petitioner, দুটা আছে। The matter was listed for in the admission column, however, due to absence of the Learned Counsel for the petitioner, matter could not be heard. It is also seen that the senior counsel, Mr. J. Kamar, is also appearing in this case. However, his name has not been reflected in the cause list. Accordingly, the registry is hereby directed to reflect the name of Mr. J. Kamar in the cause list accordingly. You're saying 10th of January.
10th, definitely.
One last time for hearing.
এইটোতো নহ'ল আৰু। কওক কাটক।
For hearing, item 39.
এইটো বন্ধ কৰিব লাগিব।
Yes, yes.
Mr. S. Biswa